Commissioners meeting this August 27th, 2024. I'm pleased tonight we have Pastor Lewis from Grace Christian Church with us. He will be providing our invocation. That will be followed by the pledge, which will be brought by firefighter Wyndham. For those of you willing and able, please rise for both our invocation and pledge.
Good evening, everyone. In Proverbs chapter 16, verse 3, it says, "Commit your work to the Lord, and your plan will be established." Let's pray. Heavenly Father, we come before you today, gratefully for the opportunity to serve our community. As we gather in this meeting, we commit our work to you, asking for your wisdom and guidance in every decision we make. May our discussion be filled with respect and understanding, and may the choice we make be just and beneficial for all those who represent. Grant us clarity of thought and unity of purpose. Help us to listen to one another with open heart and mind, always seeking the greater good. We ask for your protection over our community and a blessing upon each person here. In holy name we pray, amen.
Amen.
Please join me for the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you.
Thank you, Pastor Lewis, and also firefighter Wyndham. Our meeting is now called to order. We do not have any presentations this evening, so we will begin with our public hearings, and we have two of them on tonight's agenda. And the first one is with respect to our Department of Transportation.
Good evening, Chairwoman, Commissioners, County Manager Drew Ressler with DOT. Bentley Lake Road is a local public county-maintained roadway that runs from Barnes Mill Road to a dead end. Currently, the road provides access to 5 privately owned properties. Due to illegal dumping occurring on the roadway and adjacent properties, the property owners petitioned the county to close Bentley Lake Road, abandon the right-of-way, and issue quitclaim deeds to the adjoining property owners. In accordance with state law, a public hearing must be held prior to the closing and abandonment of a public roadway. Therefore, the department recommends the Board of Commissioners conduct a public hearing for the proposed closure and abandonment of Bentley Lake Road, located in land lots 1063 and 1064 of the 16th District, 2nd Section, Cobb County, Georgia.
Thank you, Drew. With that, we will open up a public hearing with respect to the closure and abandonment of Bentley Lake Road, and with respect to this matter only. We will take an unlimited number of speakers. You may speak up to 3 minutes per speaker, again, on this matter and this matter only. With that, I'll go ahead and open up our hearing. Okay, seeing no speakers, we'll close it and see if there are any questions from commissioners for DOT. Oh, there is one speaker. Please, sir, please approach.
Thank you, Madam Chairman and Commissioners. I just simply want to, again, reiterate the importance of privatizing the road. And we've had several vandalisms. Several times people have dumped trash. They spray painted our driveway to our church. So I would just respectfully ask that the Commission would consider this and grant this petition. Thank you.
Thank you. Sir, I'm sorry. Please state your name for the record for us. It's okay.
That was very impolite of me. Thank you. My name is Donald Crampton. Okay. I am the pastor of the church that is at the dead end of Bentley Lake Road, Galilee Church. And And so again, thank you for allowing me just these few moments. And as I promised a couple of staff members, it's rare for a pastor to take less than 2 minutes. Thank you.
You did a good job. Are there any other speakers with respect to this matter and this matter only? Okay, now we'll close the hearing. Before we vote on this matter, commissioners, do you have any questions for Drew? Okay, not seeing any, I'll turn things over to you, Commissioner Burrow.
Thank you. And thank you, sir, for coming out in support of this tonight. It always helps to get feedback from the public. So with that, I would make a motion to approve the closure of Bentley Lake Road as presented.
Thank you, I'll second it, and I just want to acknowledge that you typically have a statement that you read prior to voting.
Yeah.
Yes, and see if Commissioner
I'll give it to the
Gamble-
clerk.
Yeah.
Yes, I'd like the clerk to record the following statement with each of my votes today. As an elected official of Cobb County, I took an oath of office to uphold the Constitution of the United States and Georgia, uphold the laws of the state and our local enabling legislation. Since March of 2022, the board chair, with support of her identifying party, have requested the county legal department not to follow the law, but rather to circumvent it regarding the county's home rule authority. Just last week, Judge Hill confirmed again this action was outside the board's authority and ruled the home rule map unconstitutional. Yesterday's work session is yet another example, as the legal department claimed, and it was supported by a commissioner, that the board had discussed in executive session how to resolve the unconstitutional home rule action the majority of the board approved on October 25th of 2022. While the public is not privy to the minutes of the executive session held on August 1st of 2024, the minutes had no mention of the board discussing the home rule action and was approved 5-0 with no comments from the board as to the accuracy. Why is this important? It is not a proper item for discussion under executive privileges. We need to stop pointing fingers and placing blame on actions taken almost 2 years ago. Remember, you have one finger pointing at the subject of your dislike, but 3 others pointing back at you. This board has options, yet chose the path we are on, and it's time to accept the consequences of the actions the majority agreed to pursue. Henry Ford once said, "Failure is the opportunity to begin again more intelligently."
Thank you, Commissioner. Thank you. Before we vote, I will have it added to the record as well, even though I don't have anything pre-written, that as was acknowledged in our prior meeting, that upon the act of redistricting Cobb County without following our local delegation, I did ask for our county attorney to assess how the county could defend itself in this matter. I did not necessarily direct our county attorney and how to address that from a legal perspective, because I trust in our county attorney's office to be able to advise us on how they move forward in addressing matters of law. In addressing this particular instance, we moved forward in good faith to protect what we perceive to be the best interests of the county and the voters within the county. We have arrived to this point where our approach was found to not be constitutional, and that was a matter that we perceived was a question of law, which is why we move forward in the manner that we have. There has been a decision on that question of law, which will be in the book today, but I do find it ill-advised to imbue a direction that was contrary to law for it to be perceived that that was the intent. Our intent has always been to do what is right and to protect the interests of the county, and that will be the spirit in how we proceed with this meeting this evening. Thank you. I trust that those who are here laughing in the audience would appreciate that we not interrupt anyone who's here for public comment today in that manner. So just ask that the same respect that you desire to have as being an audience member and potentially being a speaker today, that you provide that to those who are up here on the dais this evening leading this county. Okay. With that, we do have, yes, Drew, did you want to add anything?
Just for clarity, if I could read the recommendation for that part of it, I just read it for the
Yes, sir.
public
Thank
hearing.
you.
Thank you. And that recommendation is to recommend the Board of Commissioners determine that said Bentley Lake Road serves no substantial public purpose, authorize the disposition of same by quitclaim deeds to the adjoining owners, Bentley Farm Properties LLLP, Lynn Bentley Taylor, Justin Ottinger, Summer Hour Farm LLLP, and Summer Hour Properties LLLP, and further authorize the chairman to execute the necessary documents in forms substantially similar to those attached.
Thank you for reading that in its entirety. Does your motion still stand, Commissioner? Okay.
I was like, I already made a motion.
Right. And there's still a second
there a
that
second?
stands? Yes, I seconded it. Is there any additional discussion? We'll call the question. The motion carries 5-0. Thank you, Drew.
Thank you.
We will now move on to our second public hearing, which is within community development.
Good evening, everyone. Jessica Gwynn, Cobb County Community Development Director. This evening, we have the second read for an amendment to Chapter 78 of our county code. This is actually a code that was adopted in 2021 prior to the 2021 Major League Baseball All-Star Game, which was scheduled to be hosted at the time here in Cobb County and was subsequently relocated, but next year is scheduled again to be held in Cobb County. So all that we're doing here is to take this code, which establishes a clear zone around the stadium area, around the Battery, and establishes an event area where certain activities and signage can take place. So we're thinking about peddlers and people handing out handbills, those sorts of things. And it's really going to help to ensure that we have safe and efficient circulation for our pedestrians as well as vehicles, and to maintain the aesthetics of the area. So the only thing that's changed from what was adopted in 2021, the 2021 code was very specific to the dates of the 2021 All-Star Game. The only language that's been changed in here is to reflect the dates of the 2025 All-Star Game. Otherwise, everything else is exactly as was adopted in 21. So again, this is the second public hearing, and after the public hearing, then you'll have the opportunity to vote on the amendment.
With that, we will go ahead and open up the public hearing regarding this change to Chapter 78, which is to address a clean zone for the MLB All-Star Game in 2025. We'll take an unlimited number of speakers for up to 3 minutes each on this matter and this matter only. Our public hearing is open.
Thank you, Madam Chair. For the record, my name is James Balley, and I'm here tonight on behalf of the Atlanta Braves, and we're happy to reiterate what Jessica just told you, that the 2025 All-Star Game is coming to Cobb County. We're happy to have Cobb County as a partner, and this is simply a tweak of the dates, and we'll change the dates to the 9th to the 16th. It's only for a week. It's something that Major League Baseball requires of every host city for the All-Star Game, so we think it would be a situation where it's only going to be in place for a week, and it's something that Major League Baseball requires. Cobb County still retains the power on the permitting and the enforcement of it. So we would ask that you adopt this tonight, changing the dates, and I'm here to answer any questions that any of the commissioners may have.
Thank you.
Thank you.
Do we have any other speakers on this matter and this matter only? Yes, ma'am, you may please approach. I see another individual here, so just be mindful as there are others coming up here to speak.
Sorry, I didn't.
Yes.
Yeah, all right. I have a concern about this because, as a member of the community, I've been prohibited by members of this board from handing out informational handbills at events, and there's language in here that about handing out handbills, and it says commercial handbills, but that could be, who knows how that could be interpreted. That could be interpreted to, I believe, to infringe on my freedom of expression, and I ask that the words for profit be inserted after commercial. So that read commercial for profit, so it's clear that this does not prevent expression of free speech by anyone advocating for anything they deem worthy for our community. Thank you.
Thank you.
Good evening, Holly Quinlan. I'm a resident here in Cobb County, and I'm President and CEO of Cobb Travel and Tourism. And Cobb Travel and Tourism appreciates the county's consideration of the proposed code amendments and supports the county's effort to coordinate with Major League Baseball to allow the county and the Atlanta Braves to host the All-Star Game in 2025. This is a major hospitality and tourism event that will again put Cobb County on the national and international stage. Thank you.
Thank you. Okay, I see 2 additional speakers.
My name's Craig Harfoot, and I just wanted to agree with Hill. And I could even think of, as a kid, I used to pass out tracts, religious tracts, you know. And I don't think it should prohibit that either. And because of free speech or whatever, I just want to make sure that, you know, it doesn't prohibit this. I understand, you know, you don't want a bunch of flyers on cars saying, use this car wash or that, or, you know, that's commercial. But we don't have very many places to exercise free speech. And now this was, and you might want to think about this too, about political stuff. I actually went door to door once, and I wanted to, you know, let people know that, you know, I was running and whatever, but, and it just, I had business people say no soliciting. Now, if you can't campaign and somebody misinterprets the law that much, I mean, that is not a good thing. And I, you know, I didn't argue with them. I just went on my way. But does political campaigning constitute soliciting? Soliciting is commercial. So just be careful and be clear.
Good evening, ladies, gentlemen. My name is Robbie Huck, and I am going to walk all the way to the edge of this issue and ask this board to vote no. I wasn't paying attention in 2021, otherwise you would have seen me then. The stadium belongs to the people of Cobb County, all the people. And I understand Major League Baseball rents the stadium often, but they don't ask for it any other time, just this 1 week, and I don't know why we should give them special privilege. And I looked at the map of the area, the event area, and it looks like it includes some of the private hotels, which I don't know what the government would have to do with telling the private hotels what they should allow and what they shouldn't allow. And it said something about if someone's not allowed to have a party outside that you can see from the event area. I mean, come on, yeah, I can see asking, but it's our job to say no. And I appreciate your time. Thanks.
Thank you. Are there any other speakers with respect to this matter? Okay, not seeing any, we'll close the hearing and open it up for commissioners to ask any questions. I know I've jotted down some questions of our speakers that may be better clarified. One, there's some issue with respect to the handbills, and I'm going to go to subsection C2, where it's prohibited for the sampling or the distribution of handbills for any commercial purpose. And there is question with respect to the definition of commercial and if that language could be augmented.
And Chairwoman, I think it may be helpful to provide a little context here. Many of the things that are listed in here that are specified about handing out commercial items and selling things, vendors, those sorts of things, are already regulated in our county code. We do require permits for those activities. If you go to the Braves Stadium on, any game night, you shouldn't see people out there hustling tickets. Those things are already in our county code established. So this is an additional step essentially that Major League Baseball asked, but essentially it's just reinforcing our county codes. Now to the point about the language and the commercial, if you look down in subsection E here, it speaks to the license division of the county retains its full authority to grant or deny applications for temporary permits or licenses, administer that activity in accordance with all of our applicable laws, so all the codes that are already in place, ordinances and regulations, and in considering whether to issue such permits or licenses, it's the county's intention that constitutional rights will preempt other considerations. So I think that does speak to the constitutional rights, and I would certainly yield to the county attorney if he's got other thoughts on there, but I think that provides that protection there.
And to that extent, there was a reference to religious tracts. Those wouldn't be prohibited because they do not have to be permitted. So.
Okay, thank you. All right.
And similarly, there was mention made of decals and signage. Again, temporary signage is something that we already have codes in place for. So that's already something that's not just allowed by right without any consideration of the county code.
Okay. I'm looking for the subsection 2. I think I recall reading something similar. It talks about parties or events held within a certain area. I just don't see that immediately in my review of this.
There is the language in F that speaks to signage, speaks to the All-Star event period. I don't recall there being anything in here about parties. I'm going back looking again. 7. C7.
It's
Okay,
item 7.
hospitality
Oh, yes,
events.
the hosting
Gotcha.
of any hospitality events or other activities conducted outside, which can be deemed rather broad. If there's any other activity, and I would just ask if the attorney for the Braves can just provide some clarity for that.
Thank you, Chair. Again, for context, this is something that Major League Baseball requires at every city for 1 week. The ordinance doesn't necessarily fit every city.
Okay.
Cincinnati may have a different set of rules and regulations, and they may not have such a world-class facility like we have with 60-odd acres already under the control of the Atlanta Braves. And if you notice on this map, almost all, if not every section on here is privately controlled. They're already going to ban everything on here already because these are where events are going to be hosted by the Major League Baseball. If you notice, if you look at the map that's been attached, if you see the large amount of white space, all of that activity, provided you get the permit from the county, is allowed there. There's ped bridge rooms all over the place that you see now when you go to the game. So from that perspective, I don't think it's going to create any kind of hamper on free speech. And in fact, it was written exactly that way so that it would not.
Okay, I remember being involved in some discussions when we had the football game here, the big game, as we had to refer to it. And I presume that there will be similar contracts with those private entities about activity on their site, which
and
may
it'll all
be consistent with the language that's here.
And they'll enter into those contracts with Major League Baseball and coordinate it. And it's really just to have a coordinated area. Does Cobb County and Marietta need it as much as maybe some other areas where you have a 10-acre footprint of a stadium? We probably need it less, but again, it's not the Atlanta Braves that want it necessarily. We want it as our partner of Major League Baseball, but Major League Baseball requires it of us.
Okay, thank you. Commissioners, do you have any other comments or questions regarding this matter? Okay. Jessica, if you can help guide us in our vote. Excuse me, Director Gwen.
At this point, the staff recommendation would be that the Board of Commissioners approve the amendment, the code amendment to Chapter 78 of the County Code.
Okay, and considering that this is fully encompassed in District 2, I'll defer to you with our motion, Commissioner Richardson.
So moved. Second.
Is there any additional discussion? Call the question. The motion carries 5-0. Thank you.
Thank you.
That takes us to our first public comment.
Yes, Chairwoman, as the board provides the podium for public comment, it's appropriate to review the related meeting rules. Please state your name and if you're speaking on behalf of an organization. All comments should be made to the commission as a body and addressed through the chair. Public comment is not a dialogue with the board, but an opportunity for speakers to provide their comments to the board. Comments should not be slanderous. The board encourages, regardless of the topic, for the audience to be respectful and courteous to all speakers. Everyone attending this meeting should give others the right to both listen and to be heard by treating each other with civility. Statements made during the public's comment portion do not necessarily reflect the opinions of the board or the administration of Cobb County government. And for those that are speaking, there is a 3-minute timer that's on the podium for you to speak. Melissa Johnson is the first public speaker.
Do I need to move this? Yeah, okay. All right. Good evening, Chairwoman Cupid and Commissioners. I'm Melissa Johnson. I'm President of the Vinings Village Homeowners Association, District 2 in Cobb. I'm here representing the interest of the Vinings community. My comments pertain to the potential removal of Commissioner Richardson prior to the end of her term. The commissioner was elected by District 2 constituents with the expectation she would serve the full 4-year term. I'm not an attorney, and I don't understand all the nuances of the laws surrounding this case. However, I am aware Judge Hill was clear that her order did not vacate Commissioner Richardson's seat. If the commissioner's seat is vacated, the seat would be empty until the special election in 2025. Now, I've heard the remaining commissioners could appoint an interim commissioner to fill an officially vacated seat. However, such action would not be upholding the will of the constituents. Leaving District 2 unrepresented or represented by a person appointed, not elected, for the remainder of the term would be unfair to District 2 constituents, the commissioner, and the county. Commissioner Richardson has worked diligently to understand community issues. She reviews the facts presented by all sides and makes decisions after a thorough evaluation. We respectfully request that Commissioner Richardson remain in her seat through the end of her term and until the conclusion of the special election. Thank you.
The next speaker is Hugh Norris.
Good evening, Commissioners. Hugh Norris here, a longtime Cobb property owner and resident. I watched a 38-minute video of your board meeting yesterday. I would first like to virtually toast Commissioners Burrell and Gambrell for their allegiance to the constitutions of the United States and the state of Georgia, and to the rule of law and to Cobb County rules. Thank you. In my opinion, Cobb County leadership, as controlled by the 3 majority Democrats on the Board of Commissioners, is a clown show. Those of us who followed this 2-year cluster mess regarding the establishment of a county home rule legislative map felt from the start that the laws and rules and constitutions would be disregarded and usurped. As Commissioner Burrell stated yesterday, it was immediately clear to her that a second legal opinion was necessary, as, paraphrasing, she felt decisions were possibly being made on a political basis, not constitutionally or lawfully. This is very disturbing to me. Here, a fellow commissioner sincerely requests an independent outside legal opinion, and she is denied repeatedly. I consider the denial of Commissioner Burrell's request for an outside legal opinion to be a total lack of respect for her. I have attended numerous Board of Commissioner meetings, and consultants are frequently chosen at the drop of a hat for not inconsequential costs, and yet Commissioner Burrell is denied, and we've experienced a 2-year cluster mess. For some reason, Councilor Rowling and his legal department are sacrosanct, while other county departments appear to be considered chopped liver, so consultants must be layered on. In light of the recent court rulings, Mr. Rowling's competency and or potential conflicts related to politics should be examined, as Commissioner Burrell indicated was a possibility. And while I'm not calling Mr. Rowland a weasel, I do feel his comments at yesterday's meeting, and this is my opinion, were rife with weasel words. Paraphrasing, Mr. Rowling indicated Commissioner Burrell's approach to deal with the cluster mess could be carried out. Mr. Rowling, how about following the rules and laws and stating Commissioner Burrell's approach must be carried out? In closing, I note the AJC estimates that the added District 2 and District 4 elections next year will cost $1.5 million.
Thank you, sir.
How about y'all chipping in?
The next speaker is John McLean.
There's a stop sign out in West Cobb near my home.
Please state your name for the record.
John McLean.
Thank you.
There is a stop sign out in West Cobb near my home that I think is ridiculous. But if I decide not to obey that sign, I will be breaking the law. And eventually, I will get a ticket. So I've decided to obey the law and stop at that sign. The 3 Democrats on this board, led by Ms. Cupid, think that the legislative maps legally passed by the Georgia legislature and signed by the governor are ridiculous, so they ignore them. They illegally declare home rule. They broke their oaths of office by disobeying the state constitution and ignoring state law. Georgia Code 1016-1 describes a penalty for violation of the oath of public office. I quote, "Any public officer who willfully and intentionally violates the terms of his oath as prescribed by law shall, upon conviction thereof, be punished by imprisonment for not less than 1 year, nor more than 5 years." What I do not understand is that if I disobey a law, I get a ticket or get arrested. But if the Democrats on this board, led by Ms. Cupid, have disobeyed the law for over 2 years with no consequences yet. But the citizens in this county have had to pay the penalty. No wonder they keep raising property taxes. Take millions out of the water department and put it into the general fund. Want to charge us for a rain tax, and despite a transit system today that requires taxpayers pay $20 million annually just to keep it running, they want to charge us another 1% sales tax for the next 30 years to build bus lanes and buy more buses. They need our money. But now we are being told that the taxpayers need to pay for new elections for District 2 and 4 because of this home rule BS. Costing the taxpayers an additional $1.5 to $2 million next year. Here's what needs to happen. Jerica needs to resign immediately, as she promised she would do if home rule failed, and it has failed. Lisa Cupid, Jerica, and Monique need to reach into their own pockets and reimburse the taxpayers for that $1.5 to $2 million. They caused this, and they need to pay for the cost. The county attorney needs to resign before he loses his law license because he has recommended illegal actions. Finally, the three of you need to resign immediately before someone files a criminal complaint for breaking your oaths of office and malfeasance in office. And 4, we all need to vote for Kay Morgan for Cobb County Chair.
Denny Wilson's the next speaker. Denny Wilson.
Thank you. And Bill, can you clarify rules with respect to campaigning from the podium?
Denny Wilson.
Excuse me, Denny, I'm sorry. Just give me 1 second. I'm just trying to get some clarity from her.
That is one of the prohibitions, yes.
Okay, we'll just ask that there be refrain from campaigning, because that's a prohibition within our policy. Thank you. Denny, you may, yes. Please go ahead.
But you had other people who come in here with pens on that's campaigning for candidates, and you didn't say anything at any of those meetings.
I did not see any. I did not.
Yeah, you had a room full of pens in here at the last meeting. I'm sorry.
Excuse me, as I said from the podium.
Okay.
Within public comment.
Okay. Well, I can wear a Kay Morgan shirt in here. I just can't.
I'm speaking directly from the dais. Yeah.
Just trying to get some clarity.
I understand. But in the interest of you asking for that, we did have a question from a commissioner that's being asked to our county attorney.
Okay.
Commissioner Gambrill.
I'm sorry, Ms. Wilson, one moment. Mr. Rawlings, just to clarify, because we're now saying you verbally cannot say a candidate's name, but are we going to be censoring individuals from wearing shirts, pins, buttons, stickers that have candidates' names on them?
That would be the discretion of the board and interpretation of the rules.
Okay, so Okay, so I myself am having a hard time understanding why verbally they can't say something, but they can wear something. So I guess, again, going back to our policy, why is one in violation and the other one not?
I didn't say both of them were violations. I said it'd be up to the board on how you'd enforce the rules. It's up to the board to make that determination.
And I will just respond, Commissioner. We've had discussions as a board with respect to people expressly speaking towards candidates from the dais, and there was no disagreement among us about how that was being interpreted. And so I am reiterating something that we've had full agreement on as a board with respect to campaigning when approaching or speaking to the board during public comment. During that time, there was no discussion with respect to T-shirts, pins, stickers, et cetera. I think we can have that discussion. However, this is not appropriate at this time. With that, Denny, please.
You need to reset my timer.
Yes, give her full time. She's got 1 second. Thank you. All right.
All right, Denny Wilson. I haven't spoken to this home rule madness because there's been more important issues needed to be addressed concerning quality of life that fell on the deaf ears with this 3-2 board. But some of what I heard yesterday was really mind-blowing. I heard a demand for the trust for the county attorney. As I've said before, you have constantly undermined county staff abilities to do their jobs by bringing in paid consultants. And now you want trust, but only for the county attorney. Where's your trust for the rest of the county staff? And then to say it's not about the R in the D, but it's about the R in the W, which is about right and wrong. When you created this mess by violating your oath of office to uphold the Constitution of Georgia, if that hadn't happened, we wouldn't be here. So that sounds like the pot calling the kettle black. If Richardson was a Republican, would she be going through this? In 2000-ish, under the leadership of Speaker Tom Murphy, Georgia had the worst gerrymandering map probably in the history of this state. They were so bad that the federal government came in and struck them down. There was a former Democratic U.S. Senator who went to his grave believing that he lost his Senate seat because of those maps. The home rule maps didn't come into play then, as I understand why. You guys, we got to find a common ground. But we never will if we have commissioners looking down their glasses, dressing down taxpayers, and calling them names. Come on. I mean, we're much better than this. And also, stacking the room with law enforcement is a form of law force intimidation, something that you've gotten pretty good at. But you're the same person in 2012 who accused 2 police officers of racial profiling you when they were only concerned with you getting home safely. Your comment, police tailed me because I wasn't white and in an affluent neighborhood. Now you want to unleash them on taxpaying citizens. I was escorted out of this very room at the request of Mike Boyce. And it wasn't because I was black, it was because I disturbed his meeting by yelling out, as you should remember. I could have used the color of my skin, but I chose the path of righteousness. You should try it sometimes as well. It takes so little effort to do what's right, but it takes a lot of thought put into it to do what's wrong. You guys need to get on the path of righteousness.
Tracy Stevenson.
Hello, my name is Tracy Stevenson, and I found out yesterday I'm in an abusive relationship. I was verbally abused just yesterday as I was accused of racism, misogyny, being a J6er, and a gang member, either a Crip or a Blood. Not sure where I fall on that. The only thing I have done to bring on this abuse was to ask the BOC to obey their oaths and follow the Constitution and to lower taxes. I want the BOC to be servant leaders rather than treating me like their servant. I was told that if it had been a Republican seat under fire, that I would have advocated differently. That is wrong. I'm a constitutionalist, even when it does not rule in my favor. I have voted for Democrat and Republican candidates in the past and choose based on policies, not party. And the attempt to reduce me to that is more reflective of who you are than who I am. My abusers justify this abuse by telling me that I am the abuser, that I have said and done the things they actually did to me just yesterday from their bully pulpit. Accusations were made, painted with a broad brush, which in no way applied to me. I have always treated the members of this board with dignity and respect, and if I felt that I may have been wrong, I sent them apologies the very next day. I have spoken many times from this podium about the home rule debacle and the unconstitutionality of it. The courts have proved me correct 4 times by my count. This last one definitively enough for the chair to finally acquiesce. Never have I advocated for Ms. Richardson to vacate her seat. I have actually stated that she should be able to finish her term. I have also stated that, in my opinion, all of the commissioners agreed with that position. The home rule lawfare was a waste of time, money, and court resources, and was never about protecting Ms. Richardson's seat. It was about power, expanding this board's power over those they were elected to serve, but instead have opted to rule. It was about seizing control over who draws the district maps now and then and in the future, so you could do what you accuse others of. A simple charter modification would have saved her seat with no litigation, just state legislature approval. The final tax increase hearings the last 2 years confirmed this pattern of abuse, as the vast majority of speakers were against the tax increases. However, at the end of the tax increase hearings the last 2 years, some commissioners looked down their noses at us and said that we did not speak for everyone and that they know better than we do. So they passed their tax increases along party lines, and yet turn around and state they put party over people. The hubris of that. I just need to know which of you are the Bloods and which are the Crips. I'm tired of the abuse.
Mr. Stevenson,
And I
your
demand
time's up.
Thank you, sir. Your time is run.
Matt Segal.
Hello, my name is Matt Segal. I live in District 1. I also serve on the Transit Advisory Board. I just flew in from Europe last night, and I kind of wish I wasn't here tonight. And if I was, I wish I was able to speak about transit. But I'm here to speak about something else tonight that most of the other speakers are speaking about. You know, I heard from one of my mentors, we always look at the past to understand the present, to plan or prepare for the future. And I look here today, and that's kind of just been ringing around in my mind. And if we look at our past, our county, our state, and our country have a history of suppressing and reducing the vote of the people. I'm not a lawyer, but I do know right from wrong. And that might be subjective to some here today, but history is usually the ultimate judge. And for some of those pounding the current laws have often been the measurement used for suppression. It's often been the thing used to suppress the vote. And make no mistake, today is a culmination of a systemic process to silence the 50,000 voters who voted for Jerica Richardson to serve her 4-year term. Quite simply, that's just wrong. I have faith that as we continue to progress as a county and a country, history will look ill upon today and all of those people who had some form of role in orchestrating what's happening today. Jerica, I just want to say thank you, for your service, your grace here in all of this, and also your commitment to your duty to serve. I also want to thank everyone who has done everything they could to right this wrong. I know that there's been, the legal results and all of that, but I do believe that fighting for this and fighting for those 50,000 voters was the right thing to do, and history will show that, and history will show that those who have orchestrated everything that's been happening the last year or two, history will look ill on that. Thank you. Have a great day.
Virginia Choate.
Virginia Choate. Are you planning to continue to ignore the Georgia Constitution tonight in regard to the dissolution of the Home Rule map? Chair Cupid, yesterday you accused us of not trusting the employees of Cobb County. In my opinion, unless the Cobb County attorney is an expert on Georgia state law, we should have an outside attorney looking at this situation. Since I'm guessing the Cobb County attorney allowed this illegal home rule map or did not do enough to stop it, he should stay out of this debate, in my opinion. Following the Georgia Constitution is not optional. Chair Cupid, it was shameful to hear the 4th District Commissioner allude to racism to defend her stand on not voting to follow the Georgia state law to repeal the October 2022 vote for home rule. People have the right to be shocked when hearing this and to be able to drop their head without being told to leave. Calling Cobb citizens gang names is a very low level for someone that is supposed to be representing them. Comparing Cobb citizens to the 2 thieves on the cross next to Jesus is also shameful. If one does not have a better argument than name-calling, then one should remain quiet.
Debbie Fisher. Ms. Rosman?
Excuse
Oh,
me.
Ms. Rosman?
You need to distribute that over
It's
there.
de-
They'll pass it to us. Thank you.
All my life, I've wanted an assistant, so. Debbie Fisher. I've just had the ACG guide on abuse of power distributed to the majority members, as well as legal counsel and the county clerk to put it in the record. The ACG guide covers abuse of office, conflicts of interest, ethical standard offenses. The following includes all by actions of the board: approving a resolution to test the authority of home rule powers. You ignored exceptions to the home rule by taking actions that affected elective county office, as well as taking action that affected the composition, form, and procedures of elections. Other breaches include conspiracy to defraud by claiming that home rule resolution was legal, and redistricting prevented Commissioner Richardson from serving. You ignored an easy remedy by simply changing local law that would have allowed her to continue her term. Your unprofessional conduct in office includes lectures and public shaming, disallowing comments from only certain commissioners. You continually threaten, I was yesterday, to remove citizens from meetings. The chair's disrespect for commissioners who are in opposition is obvious. You have committed offenses for public records by refusing to rescind your unconstitutional resolution and an omission of the Republican statements from meeting minutes. You have committed violations of the Open Meetings Act, as the special session that was called was not properly noticed, as no reason for executive was given until after the fact, and then that was citing potential litigation instead of the real cause, which eventually was made notice that it was about filing yet another appeal to keep this in court. You have used oppression and tyrannical partiality by interfering with elections through lawfare. You've deprived voters their rights to vote. You've been using two different maps, which is causing extreme chaos and confusion. You use deliberate means to delay or avoid the due course of law by repeated appeals, ignoring even Supreme Court judge comments and rulings on the constitutionality of your actions. You've created malpractice.
Ms. Fisher, your time's up. Christine Rosman.
It doesn't seem on.
Okay, there we go. Okay. We're experiencing lawfare, I think. Are we not? Lawfare, definition, the strategic use of legal proceedings to intimidate or hinder an opponent. I think this is what we're living right now in Cobb County. And I don't know if you're embarrassed, but I am embarrassed for you. I'm embarrassed for my county. I have amazing respect for my commissioner, Joanne Burrow, that she is committed to the oath that she took, that Kelly Gambrell is committed to the oath in which she took, and that is to follow Georgia state law, follow the Georgia Constitution, follow the United States Constitution. And there are three of you that you believe, apparently, that the rules are for thee, but not for you three. and we are sick and tired of it. We need representation. Are you not embarrassed that I have friends over in East Cobb, and I'm sure other places all over, because who's my commissioner? They don't know because it's a different one on the Cobb County website, elections and registration, and it's a different one over at the Secretary of State. What district am I in? Don't know. Don't know. And we have an election coming up. You have squandered a hell of a lot of money and time, and you are abusing the citizens of this county. And we've had it. You've taken elections, have been taken hostage. How do you do that? Is it secret meetings? I don't know. I don't know how it's done. But I can tell you, we do not trust you. And it is time that you put your citizens first and not, is it NGOs? Is it these non-government organizations that are telling you, that are driving you to do this? Because if you can take down Cobb County, whoa, you can take down the rest of Georgia. Thank you.
Hill Wright. Hill Wright.
Hill Wright, we have a crisis in this county. Our leadership is ruled by a small mob trying to consolidate power, enabled by attorneys who would advise that they overthrow the Georgia Constitution to do it. In October 2022, 3 members of this board voted to adopt illegal maps. These maps were a partisan bridge too far because they created districts that would statistically elect only Democrats in all 4 districts. These maps were about consolidating power, and thank God we have checks and balances in place to prevent it. But their vote was an end run around the checks and balances. The justification concocted was to keep Commissioner Richardson in office because she moved, and as she told me face to face, Representative Eric Allen assured Commissioner Richards that he would protect her seat if she moved. So she moved to the very edge of her district. The legislature drew the maps per the Georgia Constitution as they should have been, a natural consequence of her decision of what she was no longer lived in her district. Now, this board could have petitioned to change Cobb law in February 2022 so that she could finish her term without residing in her district. The board could have invoked home rule to change Cobb law with as much authority as they had to change the maps. It would have done much less damage to Cobb and kept Commissioner Richardson in office. For the record, I did not want to see Commissioner Richardson leave the board, and I spoke in October 2022, urging them to find another way to address the problem. But Chair, if I could tell Commissioner Richardson how I feel, I'd say, Commissioner Richardson, I'm disappointed in you and your fellow commissioners for trying to pick and choose our candidates and manipulating our elections. I don't care whether you go or stay. I just want the power grab shenanigans to stop. Now, I find it funny that you have item 46 on the agenda tonight voted on to be put on by Commissioner Richardson when she had a conflict of interest and will recuse herself tonight from voting on the item. Item 46 will enable Commissioner Richardson to, quote, litigate any matters that need to be litigated by Commissioner Richardson's admission. That's what item 46 is about, folks, allowing the commissioner to continue litigating to corrupt our system of government for a power grab aided by what appears, in my opinion, to be the malpractice of our county attorneys. Commissioner Burrell and Commissioner Gamble have made a compelling case that would protect the citizens of Cobb through a resolution that would undo the vote of October 2022. With this path, there is no path to litigation. But this cabal of commissioners and lawyers don't want to do so because they would allow more litigation. Ironically, this path would allow Commissioner Richardson to serve out her term. Still, she and the cabal want to create an injured party. Chair Cupid, yesterday you jumped down to throw to Commissioner Gamble for not addressing the chair, yet you immediately let Commissioner Richardson turn and directly address Commissioner Gamble. Then you let Sheffield address the audience to shame the audience and citizens. She implied that we were racist, partisan gang members who go around hanging people and act like children, taking pride in it. I think the commissioners to change your name.
Mr. Wright, your time's up. Chairwoman, that's the last of the speakers.
Okay, thank you. Thank you. I believe we are now at our consent agenda, and the matters on consent have scrolled on the screen prior to the meeting and will scroll on the screen at the end of the meeting. For the consent agenda items, we vote on these in bank, and there have been a number of revisions to the matters that are on consent. First revision that I have is to agenda item number 22, which is with respect to fire and emergency services regarding firefighting garments and turnout gear. And the cost has been added for clarification for each coat and each layer pant. And for agenda item number 25, as it pertains to emergency communications, there has been an agenda item to add clarification that the amendment is with AT&T for the E911 Viper phone system on a month-to-month basis. And there has been a revision to the minutes per the request of Commissioner Gambrell and Burl, I believe yesterday in exec, to have their statement added verbatim to the minutes. In work, excuse me, thank you, in work session. Okay, are there any other changes or other matters to note for consent, commissioners? Okay, not hearing any commissioners, I move that we approve the consent agenda as it has been revised and to authorize execution of the necessary documents by the appropriate county personnel.
Second.
Is there any further discussion? Commissioner Burrow.
Yes. Madam Chair, I'm opposed to item number 12 regarding the microtransit.
Okay, thank you. Are there any other questions or concerns or comments? All right, we'll call the question. The motion carries 5-0, and recognizing Commissioner Burrell's opposition to the agenda item regarding microtransit. With that, I believe that takes us to our regular agenda. And the first matter on our regular agenda pertains to DOT.
Good evening again. The department has 5 items for your consideration on the regular agenda. For context on this first one, earlier this year, staff identified a sinkhole on the shoulder in the vicinity of 5100 Burnt Hickory Road. Road maintenance staff closely monitored the location over the last several months. To protect the traveling public, the department recommends the full replacement of the double 72-inch corrugated metal pipe that's underneath the roadway. If approved, Burnt Hickory Road would be closed beginning September 16th for a maximum of 45 days. Therefore, the department recommends the Board of Commissioners approve a contract with Sheffield Contracting Incorporated in an amount not to exceed $472,112.89 for drainage system repairs on Burnt Hickory Road, project number B22125. Authorize the corresponding budget transactions and further authorize the chairwoman to execute the necessary documents.
Commissioner Gambrell.
So moved.
Second.
Is there any further discussion? Call the question. The motion carries 5-0.
Thank you. Our next item is to recommend the Board of Commissioners approve a contract with Sheffield Contracting Incorporated in an amount not to exceed $136,349.67 for drainage system repairs on Rosie Lane, project number B22141. Authorize the corresponding budget transactions and further authorize the chairwoman to execute the necessary documents.
Commissioner Sheffield.
So moved.
Second.
Is there any discussion? Call the question. The motion carries 5-0.
Thank you. Our next item is to recommend the Board of Commissioners approve a contract with Advanced Sports Construction LLC in an amount not to exceed $402,286.20 for drainage system repairs on Carlsgate Drive at Middlebury Court, project number X22106. Approve change order number 1 to said contract in the deductive amount of $40,200. authorize corresponding budget transactions, and further authorize the chairwoman to execute the necessary documents.
Commissioner Richardson.
So moved.
Second.
Is there any discussion? Call the question. The motion carries 5-0.
Thank you. Our next item is to recommend the Board of Commissioners approve a contract with Chatfield Contracting Incorporated in an amount not to exceed $166,517.73 for drainage system repairs on Tally Green Drive, project number X22113. Authorize a corresponding budget transaction and further authorize the chairwoman to execute the necessary documents.
Commissioner Richardson.
So moved.
Second.
Any discussion? Call the question. The motion carries 5-0.
Thank you. And for a final item by way of definition, microtransit is defined as technology-enabled shared transportation supports traditional flexed route transit utilizing on-demand technology. The microtransit pilot program services will replace the Cobb Link Flex service currently provided. The microtransit service will provide more access and convenient for transit patrons with on-demand transportation for curb-to-curb service in South Cobb County, with the ability to more easily connect to all areas of Cobb County and the Inland region through other existing transit services. In replacing the Flex service, the proposal here would result in a total $115,000 savings over the initial term, which is the initial 2 years. Therefore, the department recommends the Board of Commissioners approve a 2-year contract with microtransit pilot program services with Via Mobility LLC in an amount not to exceed $2,218,501.36, with an additional 1-year renewal option to provide Cobb Link on-demand transportation service, authorize a corresponding budget transaction, and further authorize the chairwoman to execute the necessary documents.
Commissioner Sheffield.
Drew, I want to thank you for all of your hard work on this item and bringing this very important resource to the constituents of District 4. We've received numerous emails from people having challenges, meeting their doctor's appointments, dialysis appointments, and we all know how critical those appointments are. So thank you so much. This is going to be proven to be a very critical resource in South Cobb. So thank you. So moved.
I'll second. Is there any discussion? Call the question. The motion carries 3-2 with Commissioners Burrow and Gamble in opposition.
Thank you.
Thank you, Drew. Okay, we are now at our Public Services tab.
Good evening, Chairwoman, Commissioners, Madam County Manager.
Good evening.
Parks has one item for consideration this evening. We ask the Board of Commissioners to approve change order number 1 to the contract with Southeastern Services and Equipment for the replacement of the synthetic gym floor at Fullers Park Recreation Center under the 2022 Park Splash program. During demolition of the existing floor, a second floor was discovered that took additional labor and equipment for complete removal. We ask the BOC approve change order number 1 to the contract with Southeastern Services and Equipment under the Park Splash program, representing an addition to the contract for $8,400, authorize the corresponding budget transactions, and further authorize the chairwoman to execute the necessary documents.
Commissioner Richardson.
So moved.
Second.
Is there any further discussion? Call the question. The motion carries 5-0. Thank you, Michael. Or Director. Our next matter is in the Office of Sustainability.
Good evening, Board of Commissioners, County Manager, County Attorney's Office, and all this here. I'm Kimberly White, Chief Sustainability Officer, and item number 42 is to approve a supplemental agreement with Johnson Controls, Inc. for the Alternative and Renewable Energy Solutions Service for the Cobb County Sustainability Strategic Action Plan. On June 25th of 2024, the Board of Commissioners approved the acceptance and appropriation of funds for the Department of Energy, Energy Efficiency, and Conservation Block Grant, EECBG program. The EECBG program is designed to assist states, local governments, and tribes in implementing strategies to reduce energy use, to reduce fossil fuel emissions, and to improve energy efficiency. I am asking the Board of Commissioners to approve a supplemental agreement with Johnson Controls, Inc. for the Alternative and Renewable Energy Solution Services for the Cobb County Sustainability Strategic Action Plan in an amount not to exceed $275,000. Authorize the Chief Sustainability Officer and Finance Department to sign programmatic budget and finance reports for submission, authorize the corresponding budget transactions, and further authorize the chairwoman to execute the necessary documents.
All right, so moved as presented.
Second.
Is there any discussion? Commissioner Burrow.
Kimberly, congratulations. Just wanted to clarify, is there a term for this contract, or is it just a one-time, the money's, for equipment and no maintenance or upkeep for the future?
Yes, so there won't be any maintenance or upkeep for the future. This EECBG grant is for 2 years, so all work that will be done within that 2-year term. So it will end May of 2026. This portion of it is to build the sustainability strategic plan that will tie to our county strategic plan. And once that's done, all documents will be owned by the county, and we will have that on file.
Okay. But the 275 is for the EVs, the charm centers, and the strategic plan?
No, the 275,000 is for the strategic plan. The electric vehicle infrastructure and the mini charm center have their own portion, but all of that is grant funds, and there's no match, so there's no impact to our general fund.
Okay, I see the 185 and the 97, 290. Okay, so why does it just say the 275 for the funding?
Because that is the portion for the strategic sustainability plan.
Okay, but it doesn't include the other part of the grant. So, I mean, shouldn't it be the whole amount as what we're approving?
So the Board of
grant?
Commissioners already approved and accepted the appropriation of the funds. So we already received the funds from the grant.
Okay.
So this is to move the funds to an area that we would be able to do that portion of the grant.
Okay.
Are there any other questions? All right. There was a motion and a second. Call the question. The motion carries 4-1 with Commissioner Gamble in opposition. Thank you.
Thank you.
We are now at our Support Services tab. Good evening.
Good evening, Madam Chairwoman, Commissioners, County Manager. Property Management has one item this evening. Property Management would like to request the Board of Commissioners approve supplemental agreement number 2 in the amount of $11,020,372 to the contract with Catamount Constructors Incorporated to establish the final GMP in the amount of $21,516,398 for Phase 2 Building and Firing Range Addition for the Public Safety Firing Range. Authorize the corresponding budget transactions and further authorize the chairwoman to execute the necessary documents.
Commissioner Sheffield.
So moved.
Second.
Is there any discussion? Call the question. The motion carries 5-0. Thank you.
Thank you.
We are now at our Public Safety tab.
Hey, good evening, Chairwoman, Commissioners, County Manager. Fire has one item for consideration tonight. We'd recommend the Board of Commissioners approve change order number 1 with John Spratlin & Son, LLC for additional work at the Fire Training Facility 2022 SPLOST Program B1041 and authorize a fund appropriation within the Fire Fund in the amount of $235,680.35. Authorize the corresponding budget transactions, and further authorize the chairwoman to execute the necessary documents.
Commissioner Sheffield.
So moved.
Second.
Any discussion? Just a brief comment. It's amazing to see all the improvements on that campus. We got a glimpse of that today in our work session. And
Yeah, thank you very much. You know, with the support of the SPLOST, I dare to say that our training facility upon completion will be the nicest fire training facility in at least the southeastern United States. So thank you for that.
wow, thank you. Thank you, commissioners, and to our voters for approving this SPLOST. Okay. With that, we have a motion and a second. We'll call the question. The motion carries 5-0. Thank you, Chief. Oh, okay. Our next matter is under E911.
Good evening, Chairwoman,
Good
Commissioners, County Manager. 911 has one item for consideration this evening. The department recommends the Board of Commissioners authorize the purchase of replacement portable and mobile radios with all required accessories and services in the amount not to exceed $1,634,322 with Motorola Solutions, Inc., using funds from the 2022 SPLOST Program Radio Equipment Replacement Program B1020. Approve the purchase under the provision of a Georgia Department of Administrative Services contract with Motorola Solutions, Inc., authorize the corresponding budget transactions, and further authorize the chairwoman to execute the necessary documents.
Thank you. So moved as presented.
Second.
Is there any additional discussion? All right, call the question. The motion carries 5-0. Thank you, Director. We are now at the BOC Chair tab.
Chairwoman, item number 46 is to acknowledge the finding of the Cobb County Superior Court.
Bill, we just have some discussion, so we're going to engage you on advising us with respect to this matter before you present it.
Okay.
Okay, Commissioner Richardson has a question for you.
Thank you, and apologies, but I probably should have asked before. In reading the revised version of this, I am concluding that a recusal is necessary on my part. Do I do that now or after the presentation and the question clarification?
The first recommendation is just related to the maps. The second recommendation is
That paragraph is a compound paragraph, so that's why I'm trying to figure out when I should ask, if I'm able to ask that question, because it affects the voting ability on this agenda.
the only portion that's going to be presented now is just the maps.
The first one.
So you can
The most recent version that came out includes the if passed clause. So, in other words,
It's
it's all within.
just look at the recommendation,
Okay,
not
so wait
necessarily the
till
background. Yeah, the recommendation.
Because what I don't want to do is accidentally couple
Okay.
because of how it's written.
Okay. So it's the recommendation that is being handled at this point in time. Just for the purposes to acknowledge the finding of the Cobb County Superior Court Civil Action File Number 2410-2130, an order on petition for appeal of judicial review dated July 25th, 2024 of the home rule map that was outside the authority granted to the board, and to direct the board to direct that the map set out in Act Number 562 be used for all future county purposes. That's what's before the board at this time.
Okay. So that is with respect to recommendation number 1. Commissioners, there's been some discussion that when this was initially drafted, that this was a compound motion since 2 things were being considered, which is why there are 2 recommendations before us. Again, as Attorney Rowling shared, we are now voting on that first recommendation. And I do move that the Board of Commissioners, again, acknowledge the finding of Cobb County Superior Court, and that we direct that the map set out in Act 562 be used for all future county purposes, and to direct staff to deliver a copy of this agenda item to the Georgia Secretary of State's office. Is there a second?
For discussion?
Well, yes, it would prompt discussion.
Okay. Are you going to just go down the line? Or what?
I moved, I'm looking for a second.
I'll
There is no
second, so we can get on to this discussion.
Is that a second?
Yes, I
Okay,
said I would
thank you.
second
I
for
didn't hear.
discussion.
I was listening to Commissioner Broll, and I did not hear what you stated. Thank you for clarifying.
Is that a second for discussion?
I thought you said I thought you were asking me a question. Your mic isn't on, so I didn't know if you were talking to me personally or if you were making a formal second. Okay, so we do have a motion and we have a second, and we are now open for discussion. I'll begin with you, Commissioner Gamble.
The only thing that I would suggest that we add to this motion is when we specify Act 562, that we put that was signed by Governor Kemp on March 2nd of 2022. As every legislative session, the act numbers repeat themselves, and this would further clarify which specific act we are referencing.
Okay. I mean, that would be an appropriate amendment. Now I'm playing that role back over there again now. Just to advise the board, the motion is carried, the motion is with the board. If you agree to that amendment, then.
Okay. That wasn't clear to me, Commissioner, if you can restate it.
Sure, I would like to amend the motion that is currently on the floor to include, after Act 562, the language which was signed by Governor Kemp on March 2nd of 2022.
Okay, thank you.
And are you including both sections that refer to 562 Act 562?
We are only working on recommendation 1 at this time, so my comments are specific to recommendation 1.
That's the motion that's before you.
But I'm referring to background. The purpose has 562, and under background is 562.
I wouldn't be opposed to that, but the motion I do not think has to go back and make changes to the background.
It doesn't go back to make changes to the agenda item. It's just the motion that's before you now.
Okay, I got you.
Okay, I'm amenable to that change, Commissioner. I made the motion, and I have no problem adding that clarifying language to the motion. So we'll just like to amend to add in that additional language, excuse me. Okay. Does that conclude your comments, Commissioner?
I have no further comments at this time.
Thank you. Commissioner Richardson.
Sure. I think the clarification there is fine. The reading up until the first semicolon, I would be comfortable with. It's after the semicolon where I know I have requested for clarity on what map is in effect today versus just what we are instructed to put in place for the special election. Under normal circumstances, found under unconstitutionality, the current map would continue on until the following election cycle. And so given that, I cannot lend my support for this agenda item.
Okay, thank you. Commissioner Burrow.
I'm not sure where that was going, but we've had a lot of discussion since yesterday, and I think it would be, well, I do have something else to add to the motion, but for discussion purposes, I think we need to look again at Article 9, Section 2, Paragraph 1B1. Yesterday there was a lot of discussion about repealing the home rule map to do away with it for good. However, after speaking to, when the chairwoman said yesterday that we're entitled to have outside opinions at our own expense, of course, I consulted with several attorneys that know the law, the state law, and the last sentence on page 69 of the Constitution under the Article 9, where it says, "No amendment hereunder shall be valid if inconsistent with any provision of this Constitution or if provision has been made therefore by general law. The fact that Judge Hill ruled the map, the home rule map, unconstitutional in Alicia Adams versus the Board of Elections and Registration case, that was for the election process. But by adopting the state legislative map with these revisions tonight, actually makes that the valid map and supersedes the repeal process. And
Yes, ma'am, I made that suggestion to you, trying to reach a consensus on this and provide information for the board. And so that is actually the specific reference that you were saying to yesterday. You were referencing the procedure, but this is just the acknowledgement in the code, in the Georgia Constitution, that says it is invalid if it's been not constitutional.
so this further extends the unconstitutionality ruling by the court to cover all county purposes, that we will be operating under the state legislative map for all county operations, all county purposes.
Correct.
And when will that be effective if this is passed tonight?
If it passed tonight, it'd be effective at that point in time. Yes.
So
This just clarifies, since the court order was only against the Board of Elections and Registration, then what this board is now doing is adopting that and are saying that, as it says out in the motion, so that it's also effective for the Cobb County BOC as well.
okay. So the county map, GIS, will now be adopted, be transferred to the state map? And when?
Yeah, I mean, it says everything. I wouldn't be able to answer that. I mean, this is one of the questions, I mean, maybe directed to the county manager, but as soon as they get direction, and I imagine they would start moving in that direction for all maps, for zoning, for all of these issues.
Because there's been so much confusion with the county map. The state map never changed. Only our map changed for Cobb County. So it's very confusing. But I know it's not going to probably happen overnight because of the technical issues or whatever, but I'd like to have a date certain that it is effective. And if that's tonight when the chairwoman signs everything, but could Kimberly Limley or someone give us an estimate of when it would be online?
Chairwoman, we can safely say that if it's approved tonight, I will direct staff to have it up tomorrow. I'm not going to ask them to stay late tonight, but tomorrow, first thing in the morning, staff will be directed to make sure that the map through GIS is on our website.
Okay. And then one thing I would like to add, Bill, is on the revision page, on the second paragraph under background, where it says, now this is for the map. This is for the map only. Where it says, the board directs that the map set out in Act 562, and we're adding signed by Governor Kemp on March 2nd, 2022, is to be used for all future county purposes. And I would like to add, and no further action legal action by the county.
Well,
This needs to be over with once and for all, this map.
Okay,
I'm not talking about Jerica's appeal. This is for the map, that it will be used for county purposes, and no appeals on the map or further future legal action will be brought by the county.
The county hasn't brought any legal actions related to this, not a single one.
Pardon?
I said the county has not brought any legal actions related to this map.
Well,
I mean, the motion's before the board. It's up to the board whether they want to add that piece in there. That's not at my discretion. It's the board's discretion.
but the county was denied the motion to intervene in Judge Hill's court, and the motion for reconsideration was never heard because the motion to intervene was denied. That is still out there that could be appealed.
I have received no direction.
I know you haven't, but I want you to say that you're not going to. Or I'd like the board to say that this ends this once and for all, for this case, for this map.
Yeah, I'm under a duty to defend the county if it's sued. And so I can't say I'm not going to defend the county if it's sued. If the board does not want us to, by doing this action here,
If you're
then the board
sued,
is,
you would be defending the county.
Yes.
You would not be bringing
Correct.
further action on your
Correct.
own for this.
I've not brought any action on my own. It was only at the direction of the board. So,
Wait a minute. Oh, my Lord, have mercy. Our county attorney brings action in response to having consensus of the board, which requires at least 3 out of 5. The county attorney does not act on his own volition, which is why I don't think it's appropriate for Bill to share that. It would be appropriate for this board to make that decision. We have made further assertions in the past about not binding future boards. I have never seen us motion away our legal power and option. Okay.
This is future action for this case. It's not for 10 years from now when another census is done and another board wants to bring home rule up again. It is for this particular action that we have been going through for 2 years that needs to end tonight.
I will say,
I'm not backing down.
I will say that there is no intent to bring further action, and that's the extent of which I will commit to it. We have not. Okay.
Madam Chair, if I may.
Yes.
This is for this map, this whole thing we've been through for 2 years, and this only. No other further legal action by this board or county attorney's office on this matter, okay? The next section that we will be voting on is the 10-day notice to Commissioner Richardson, okay? She has every right to appeal that within the 10 days. She has due process as everyone else, and I'm not arguing that. If she does bring an appeal, the county has to defend that and argue, go to court with that. And that's her due process. She has every right if she wants to file an appeal. But this is just for this map and this procedure that we have been going through, this process, for 2 years. And this came to us as an agenda item to approve tonight with the direction of the board to go by the legal map that the judge ruled the home rule map unconstitutional, and we need to follow that.
Okay. I agree with you. I agree with you, Commissioner, and that's why this is on the agenda. We are putting this here to accept the ruling of the judge. I think what you're asking for has already been answered to by I'm sorry that you believe that this is a conversation with you in the audience, but you are here to observe. And I'm talking to the commissioner, and I know that you, okay?
No, come on.
This is very, as your commissioner shared.
Don't, just have
Have some, have some what? What should they have?
Be quiet a minute.
What were you going to have some what? Have some respect and decency and
No, I
decorum.
didn't say that. I just telling them to hush.
I am saying that. You didn't finish it. Thank you. And we did as you spoke today. And I asked again for the same courtesy to be given as you were given when you addressed the board. Would be the same courtesy that we would expect as we conduct business of the county in addressing this agenda. This is the second time I'm stating this. I stated this at the top of the meeting. Not yet. I'm just pausing. I'm just pausing. Commissioner, again, go ahead. I'm allowing, I was responding to that change.
Can you or Attorney Blair give us some language that we could use to do this?
Commissioner, I would say what you're doing is you're putting in place the state map. That's the map that's now in place. The home rule map no longer exists. I don't know what litigation that you would say that we would be initiated or started from. The board is saying that it's been declared by Judge Hill's ruling as unconstitutional as the BRE. They're acknowledging that statement, and it's become the new map. Home rule map is now gone, or if this passes, the home rule map is now gone, and the Act 562 is now the new map. So,
Madam Chair, I want assurance and confirmation that this is going to stop and end tonight, and the state map will be in place.
What assurance do you have if this doesn't pass? If this doesn't move forward, do you have any more assurance of that than you would supporting it?
I just
See,
want
I
to
feel
know
like
that.
I'm being given two options as if they are the only two, or if that is the only option. I'm telling you that the result of us not moving this forward gets you no closer to the end that you're desiring. But us supporting what is before you articulates support for what you are requesting. I have been amenable to the condition that was asked for by Commissioner Gambrell and that was put forward by you. But that doesn't necessarily mean that anything that you want to satisfy what you are looking for needs to be met in this negotiation that we're having here today. We all have given a lot towards this process. And trust me, if everybody wanted or received everything they would have gotten, we wouldn't have even gotten this far.
Yeah.
Oh, my Lord. What a committee. Everything here is about a give and take. It is it's unbelievable. It is unbelievable.
Well, if it doesn't pass, then, and it's been determined unconstitutional, then I guess this board will suffer the consequences at the expense of taxpayer money and the three that voted for it in the first place.
Okay. Well, we already know that there will be we already know that the Board of Elections has already required for there to be another election, so there will be tax dollars spent towards that. We are already, okay, why don't we go ahead, if you guys want to have a conversation, I'll give you some time because I've got time to kill tonight. We can wait, you guys can get all of that out your system. We'll go ahead and take a recess.
You can't take a recess in the middle.
Point of clarification, Mr. Owings, can we take a break in the middle of a motion?
I can do it.
I can't hear you.
I can do it.
Point of clarification.
All conversation comes through the chair. Okay. Okay, we're in recess. We're in recess. I don't know. Continue, please.
It's been done before, Kelly.
We have with respect to an alcohol matter. All right, welcome back to our Board of Commissioners meeting this August 27th, 2024. Our meeting is now called back to order. We are in the midst of the BOC Chair agenda item, which is agenda item number 46, and the commissioners are now deliberating. We are still at Commissioner Burrow, and Commissioner Burrow, once you are concluded, Commissioner Sheffield may follow.
Okay, Mr. Rowling. Judge Hill's order deeming the home rule map unconstitutional on July 25th in the Adams versus Board of Elections case. Would you agree that the county will not bring further action? I'm not talking about if we get sued. I know we have to defend ourselves, but we won't bring any legal action or appeals from the motion that was denied for us to intervene from the Adams case.
Correct.
You agree to that?
Correct.
Okay. And does this board agree to that as far as part of the record?
I believe the agenda item as written addresses us accepting Judge Hill's order.
No.
I got time today, I really do. I got time today. Great. Good.
Can this be in the minutes or as the clerk's note or something?
Excuse me. Go ahead. I'm sorry, Commissioner Burrow.
Or let me ask this. You don't support this item at all, correct? Commissioner Gamble?
Madam Commissioner, the reason that...
Wait a minute, I'm still speaking.
I thought you asked me a question just now.
I'm asking the board their input.
Okay, am I on the board? Okay, I was responding. The reason I put this forward is because I support it. I support us accepting the judge's ruling. I think what you're asking for is emphatic. I think it's already implied. And I have already stated my position here, and my position has not changed to accept the judge's ruling on this matter. And I'm sorry, let me just, I want to go back and clarify my conversation. I have time today for us to have this meeting with proper decorum. I'm not trying to be disrespectful to you because apparently you have time too to be here. But what we have missing in this meeting is a sense of decorum, primarily from the audience. We can agree to disagree without being disrespectful. Okay, sorry, go ahead, Commissioner Burrow. Yes, sir. I responded. I don't know if the other commissioners would like to respond.
Sure, I'll respond and I acknowledge Commissioner Sheffield hasn't had an opportunity to weigh in. While I am agreeing to support this agenda item as it is being presented, it goes back to the discussion, Commissioner Burrell, that you brought up yesterday about we should be repealing the resolution. That was, and taking the steps that we took to pass the resolution. And I agree with you that, you know, yes, in order to repeal this action, we should be taking the same steps that we did to put it in place. From my understanding, from the county attorney's office, because of Judge Hill's ruling, it now makes that action invalid or moot. Therefore, according to our county attorney's office, who is our legal counsel that is advising us on this, we do not have to take the steps as outlined in the Constitution. You and I have taken very seriously following the steps of the Constitution. I still have reservations today of sitting up here and supporting this agenda item just because there has been so much mistrust. And we haven't been given the opportunity to seek outside legal counsel unless you and I funded it ourselves, which only further leads to the thought of they're trying to take one over on us. So I understand your hesitancy here, but we also have to know that this is what they are legally advising us of doing. So any further action going forward, they have to have the assumption that they are going to be able to defend it.
And I understand that. I mean, I agree, we have a right to defend ourselves, and that's not what I'm asking. Go ahead, Commissioner.
You had something else before you?
I just don't want to.
Thanks, Bill. Well, I am going to recommend that we pull this agenda item for further discussion. While I appreciate the effort to add context to the judge's ruling, there's no language, as we all know, in her decision that implies that Commissioner Richardson needs to step down. If the intent of this agenda item is to simply acknowledge the judge's ruling, I do not see the need to use language that could be perceived as a reprimand, such as the bold and underlined wording in paragraph 3. The format of our agenda item, for those that may not be familiar, it states, the first paragraph states the purpose of the agenda item with a background paragraph that provides context. However, the second sentence of the background paragraph does not provide background information. Instead, it expresses an opinion about avoiding ongoing confusion. Additionally, recommendation number 1, as it is currently worded, while the first sentence of recommendation number 1 acknowledges the judge's decision, the second sentence directs that the maps outlined in Act 562 be used for all future county purposes. That sentence implies that the judge ruled in favor of using the state maps for all future county matters, which is simply not accurate. That is the inference of that paragraph. Therefore, I do not support this agenda item as written and recommend that it be pulled until further discussion. There was an email sent to the board requesting feedback regarding the agenda item. There were recommendations that I submitted for this agenda item that were not captured in this agenda item. I think all of our opinions are important, and I think that while we are wanting to get to a resolution, I think it should be done in such a way that supports all of, or at least most of, the requested feedback from this board. As we discussed this evening, there are a lot of questions still. There are a lot of recommendations with respect to revising the language, which I do not think would be the most prudent thing for us to hash out on the dais. This agenda item is it's very similar to any other agenda item that we need to pull for further discussion if there is not a clear consensus moving forward. There were a lot of recommendations again this evening that we are being asked to take in consideration of one another and incorporating that into a revised agenda. And until we get to that point, I am not supportive of this agenda item. Thank you.
Opinion? After our discussion yesterday, it was clear that there was not a meeting of the minds of a majority of this board with respect to this matter. I still believed it was the proper thing to bring this forward because there has been a ruling, and right now there is not clear direction for how we're operating as a county. And I respect the fact that you share that there's some implications with the judge stating that she supports the state map. There's two maps in play. It's either our map or the state map. Perhaps I just don't see a gray area there. And I shouldn't say our map, it's the local delegation map that was put forward that we asserted under home rule when I say our map. Either way, all I can tell the board, whether you have been for this assertion of home rule or whether or not you have not been for this assertion of home rule, not supporting this today will continue a lack of clarity for our organization and for our residents, and it will undermine an acceptance of the ruling of the court. Even with that being stated, though, for practical purposes, it makes sense for there to be a majority in support of what moves forward. But I do believe that it's important for us to have this conversation and for us to understand the level of complexity and confusion that it causes once there has been a ruling that's determined that our maps are unconstitutional. As an aside, I will share this. There has been a lot of assertions about the politicization of this entire process. And I just want to make some observations. If this were moved forward to support the Democrats and to be partisan, it would have been very easy to accept the state map. Because the way that the new District 2 is drawn, it is drawn in a highly partisan way that leans Democrat. This was not about politics. This was in recognition that in bypassing a tradition of depending on maps and redistricting out of a local delegation, that it has caused angst for a community, for a county, which we thought had some significance, being the third largest or most populous county in the state of Georgia. And I would concede one of the best run counties in the state of Georgia. Perhaps which is why we moved here. Well, this is also novel for us, and it's led to complexity and confusion because I can't remember a time when redistricting has occurred where someone has been redistricted out of their seat. Upon that happening to us here, and I've been here for going on 12 years and have been part of a redistricting process. At its core, as was asserted by our first speaker, something seemed amiss in disregarding the will of those that elected their commissioner of District 2. And the same concern we had that in redrawing those lines would place the commissioner out of her district, and our law says that a district commissioner must live in the district, is what's prompted this agenda item today, at least the second part of it. That upon accepting this map of the state, or accepting the ruling of the judge, which would imply acceptance of the map of the state, which will clearly articulate, Commissioner Richardson would still be outside of the district, which means her seat would be vacant according to our law. So the same issue then is still the same issue today. The only matter that has brought this far is us asserting what we could do under what we perceived was a question of law. That's what got us to where we are today. The question of law has been answered. In going into this with good faith, I'm putting this matter before commissioners in good faith today to accept the ruling that our assertion of that map, supported by the local delegation, put forward by Home Rule, has been ruled unconstitutional. I'm concerned, but I accept if we do not move forward with this today, just understand where we will be tomorrow. We will be in the same position of not accepting the judge's ruling now that we know it's been made clear by law. We would still not be accepting it and providing clarity, nor recognizing that with asserting that the map under Home Rule isn't unconstitutional, having someone still serving on our board whose seat is now vacant, we're going to be in the same position. So it may not be perfect what you see before you today. I'm all for us working together if we feel there's a more perfect way of putting this forward. But I am desiring for us to move forward. Whether or not you're on one side of this issue or the other, we have got to move forward.
Chair, I just want to add that me not supporting this agenda item should not be interpreted that I do not accept the judge's ruling, because I do. I just want to make that clear.
Okay.
But I am not comfortable with moving forward with this agenda item as it is written today.
Okay. Yes, Commissioner Braun.
I think when you said you agreed with, we wouldn't bring anything appeal for the judge's ruling, for the record, I will concede to that and just accept the changes that have been made. This has to end tonight. It's been going on way too long, and I've said many times it should have never been done to begin with, and it was our local enabling legislation that was keeping, that says you have to live in the district you represent. We have all said from the very beginning, including Commissioner Gambrill and myself, it was not fair that Commissioner Richardson was drawn out of her district. We never said we were fighting this home rule issue because she was drawn, she was drawn out because of, and I don't want to get into this because of yesterday, but it wasn't about race or political parties or anything. The bottom line is we don't have the authority or jurisdiction to draw our own lines or to implement a map. It's only up to the legislature. They have the powers. The challenge was made, and we had to go through the court process rather than amending our own local enabling legislation that she should serve till the end of her term.
Okay.
That was not, I mean, I'm all for that. Okay. So I am ready to move forward with this as it was presented and revised and call the question.
Thank you. I just have a question of clarity, because you've been here, you're the most tenured commissioner here. I follow you in seniority. When the maps were redrawn during the last census, what maps were followed? Was it not the map of the local delegation?
Actually, I've been through 3 redistrictings in 14 years. And even though every 10 years we're bound to do them by law because of the census, in 2012, when the maps were done by the legislature with a Republican delegation majority, they didn't get them in the legislature, and a federal judge, Steve Jones, had to draw the maps. This was right before you came in 12. And we all, 5 of us, went down to the Capitol and met with him, and there was one minor change that one commissioner asked to be changed, and it didn't affect the numbers, and he granted that. And 2 years later, in 2014, the Cobb delegation, which was predominantly Republican at the time, redrew the maps because they didn't like the judge's map. And Bill can attest to this, because with this home rule going on now, my own party had issues. I had issues with the maps that they gave us in 2014. And I asked Bill from the very beginning, if I'd known we could do home rule and change our own maps, you know, why wasn't that an option in 2014? So typically, the local delegation does draw the maps, and it depends on who's the chair and who's in charge, if they include us or not. And but the way that it was done was by the General Assembly, not the local delegation, because the Eric Allen map, as we call it, the home rule map, never made it out of committee to the floor for a vote. But the map that Senator Setzler presented was the one that was passed by the full General Assembly. There's nothing illegal or unethical about that. That's just the way they did it. But I will say that when the Eric Allen map was presented to us, 3 out of the 4 maps were of the 4 districts, 3 out of 4 were predominantly Democrat, and District 1 was 50-50. And I was up for election, and so was Commissioner Gambrell, and the map that he presented made me 46% Republican, and I run as a Republican. So, I mean, that wasn't fair. And then Senator Setzler's map, actually 2 districts were predominantly Republican and 2 Democrat. But my whole basis for this, fighting this, is the Constitution and upholding the law. We don't have home rule powers when it comes to redistricting, and that is plain and clear in the Constitution and the state law.
Thank you, Commissioner. I'm just going to respond. It is clear. It is very clear now. Again, were it not considered a question of law, we would not have been here, and we would not have asserted what we asserted. I appreciate you walking through that process, because I want to acknowledge that this process has traditionally been done with our local delegation. Because when we were being redistricted in 2014, I remember making those calls and being told specifically by a leading member of our local delegation, you are the county, we are the state representatives, we make this decision. But the contrast to 2014 to 2021 was they didn't make the decision. And I think that has been lost here. This happened to us. This happened to Cobb County. And somehow what happened to us is now turning us against us. And that is the grave misfortune of it all. We have opportunity to come together in solidarity to move forward. And I'm looking for us to do that. A great harm has been done. And we can't go backwards. But I certainly am grateful, even though I know we're on different sides of opinion, I'm grateful for us standing up for Cobb County and the voters that voted for their district commissioner. We legally fought as hard as we could, but when the fight is over, it's over. And will concede that. I have no problem doing that. In good faith, we went in, and in good faith, I have no problem recognizing where we are today. So I'm in support, again, of moving this forward. I don't know what additional clarification of language, and perhaps Commissioner Sheffield, you could weigh in. As I was willing to accept Commissioner Gamble's change, I was willing to accept the initial change that you had. And I'm ready to move this forward.
I was just going to add a little context about Eric Allen's map, and I just wanted to be clear, the Board of Commissioners did not draw their own map. That was Eric Allen's map. And Eric Allen met with, I believe, the majority of the board to get us to weigh in on his proposed map, to which we did. And I recall Commissioner Burrow and I were down at the Capitol, and I stood alongside my colleague to meet with Eric Allen to discuss the map. And it was brought to his attention that District 3 would have been 46% Republican, to which Eric Allen said, when we draw the maps, we don't consider political party. It's about the residents of Cobb County. However, he still took that into consideration, and he proposed a new map, which that still was not supported. So I just wanted to add a little context around Eric Allen's map.
I agree with you almost 100%, except I do know redistricting is very partisan. Drawing lines is very, I hear you, it's very partisan. Yeah, but I do know that, Commissioner Burrow, we were all concerned about you when we found out how skewed the new District 3 was under that map, which was why we supported going back to the state and working with you, and I think we worked with our county, the attorney's office, to see if we can balance out the population in getting that map changed. So, again, we are.
I was part of that as well.
Yes.
Because you have to be sponsored by a legislator to go down. And in 2014, Sharon Cooper gave us, me and Commissioner Ott, and the board was different then, but sponsored us to go down and look at the maps. in the redistricting, reapportionment office. And one of the county attorneys at the time who was familiar with all that went with me and Commissioner Thompson. And, because we could only go two at a time. And we did what we could to come to an agreement. Well, in 2022, when Representative Allen at the time was chair of the delegation, and he gave me the authority to go down, and I went with Attorney Brian Johnson. And we looked at all different scenarios of how we could shift the precincts to keep Jerica and Commissioner Richardson in District 2. And from the divider line up to her precinct, the numbers didn't work, but we did look at that, and I did, try to see, but it still was lopsided. The numbers didn't work. And so that's why I voted against the map, not because of her being drawn out of her district, because we've said all along that wasn't fair. So I'm just, I'm ready to resolve this once and for all. It has been 2 years of hell going through this.
I hear you. Commissioner Richardson, I think you wanted to say something.
Just going to provide even additional context. It was mentioned about the concern in your seat, so much so that I received a call in trying to understand how the map could better accommodate some of the requests you made. And my response was, whatever she needs, it's fine. If you make it harder for me to win, I'll just have to run a better campaign. And then I made a joke after that, because it usually is not of relevance. I said, as long as I still live in the district, because that has not been an issue yet in the tradition of map making for Georgia's, in the times that we've been making maps. It was a joke.
Well, and did you know that there was also a map under consideration that had drawn me out of the district?
That was actually something that we had heard and discussed. And part of the reason why we brought forward if you recall, was not a part of a specific structured procedure, but we wanted to show that we liked the open, transparent process of talking to us, or at least keeping us informed and using a process that's been tradition for, I don't know, decades since map making. And so even though we each had issues with the map that the local delegation was drawing, we wanted to show that we were supportive of the fact that there was open conversation. Because, yeah, there were several rumors circulating that different commissioners were being drawn out. And again, this is something that has happened to us. And we're trying to figure out how to navigate that as a community because there are impacts.
Yes, Commissioner Gamble.
Okay, so I feel like I need to put on the record that I was not involved in any of these map discussions. But also for the record, I think we need to remember that Cobb County had an issue with what the state legislature did, the General Assembly did, but we never took legal action against them. We never challenged it. We never asserted our authority with the state. I would also like to point out, in the law, OCGA, sorry, my computer turned off, 28.1.14.1. The title of the chapter is Requirement for Revising Districts
proposed plans submitted electronically and legislative requirements, but essentially it outlines how the Board of Commissioners could have gone to the General Assembly and asked for a different map to be substituted in. Again, the board made a decision not to pursue this path. This was an option that was available to us, but we chose not to do it.
Okay.
Was that option presented? Go ahead.
That's my first time ever hearing that at all, so I definitely would like to see a copy of that. But the one thing about challenging the state legislature, they certainly were challenged by not just members of this board, but challenged by members of the community who made their way out in the middle of the day to go and ask questions and try to understand what was happening. But the reality is that they also did nothing unconstitutional. The procedure they took with both maps that they drew were constitutional processes, to your point. Now, it slaps the face of tradition, but they were constitutional. So you can't bring an action against any entity if there is nothing to, there's no legal basis to have that standing, which I think everybody has gotten ample knowledge on standing and how that works within our court system. But as far as the conversation about the maps, I was even aware of some of the, and maybe this was misrepresented, but I understand that there were some pieces of the map that were desired between 1 and 3 as well, in that upper north corner. So maybe that came through courier, but that was also a discussion that was on the table with regards to the Lake Green properties. But again, like I said, that's my knowledge, my full knowledge of what went down with the different map discussions, and certainly with the constitutionality pieces and what was discussed at the state capitol, because we certainly spent ample time with them, and all that's on the record, it's recorded, those different statements, what was expected by their legal counsel, the challenges on the vacancy, multiple statements being made, all of that's in record that you can go and watch if you're at all feeling nerdy.
Did I see a hand up over here? Earl or Sheffield? Okay.
Oh, I'm sorry. Commissioner Gamble, go ahead.
Yeah, I feel I need to respond because, again, it was alluded that there was a conversation about where districts 1 and 3 came together at Wade Green, and again, for the record, I was not privy to those conversations. But I think while this applies more to the second part of the agenda item, to which we are not discussing, it plays into the conversation we are having now regarding Act 562, and I know it's been debated greatly by many in the community, and that is the language that is included in here that essentially states that you get to finish the term. And ironically, that is in accordance with state law, that you can finish your term. Cobb County, because we have home rule authority and powers, we can make our laws more restrictive than the state. This board had the opportunity to change our residency requirements. Now, I know you're going to say, oh, no, we can't, but again, we have the ability to change our laws. We are the lawmakers of the county. We are setting the laws to which the board is supposed to follow, which we'll get to in B next. But we also had the opportunity, because remember, the maps didn't go into effect. Yes, they went into effect immediately for the elections, but essentially we had time where we could have gone in and amended our residency requirements and essentially put in language to allow for a term to be finished if a commissioner was drawn out of office. Again, that was not an option, and I know it was said before that, well, that wasn't brought up. Well, maybe it wasn't brought up because going back to Commissioner Brohl and I's anger over this whole process is because it has seemed like there has been a majority conversation and we have been left on the outside. So maybe if we would have all sat down like we are collectively doing right now and talking about the different ways to handle this, this all could have proceeded differently over the past 2 years.
I truly appreciate you sharing that. And that felt like that was a sentiment, that there was a lot of anger. But I can assure you, there was no offline conversation. And I think the actual partisanship of our board may make things seem as if they are more partisan than what they truly are. There have been times where each of us has disagreed with all of us, and the three of us have disagreed amongst us. And our debate and our issues get played out publicly like everyone else's. And I'm hoping that moving forward, even though this is a split board, 3-2, that we can perhaps dispel that untruth. There is no committee meeting, no offline discussion. We all have very busy lives, and we all are different and have our disagreements. But when we come together and talk about policy, I'm of the perception that each one of us, whether Democrat or Republican, are doing our due diligence when we come to the table to determine how we're going to vote. And that's perhaps going to be displayed today. Yes, Commissioner Richardson.
And I will just share for the record, the only conversations where we've had legal discourse about actions that could possibly be taken in different viewpoints and asking questions about, honestly, all components of this has been when the five of us are together in exec, where those questions do get asked. And I know personally, I've spent time with you one-on-one for several hours when this first occurred as well, because I have a significant amount of respect for your attention to detail. And I've shared that with you many times. The members of the board as well, they know I've spent time with them, going over all the different options. These options are not options that I've heard. There are other options that I've heard from different members that, certainly pose some other constitutional concerns, but I do just want to say for the record, there was definitely, I know, one-on-one dedicated time where we had this conversation, because when this first happened, it was understood that this could happen to any elected official anywhere, and that this was an opportunity where we could come together and determine what the best option was to protect this county, but not just this county, but other counties as well around the state of Georgia. That has always been the intent and my contention, and the way in which I've carried about all conversations related to this matter with members of this board and members of the community, and certainly anyone else who asks.
Yes.
And I will concur that, yes, we did have discussions, and I also remember you telling me I was wrong. And it seemed like it never went beyond there, because again, I said these same things to you then. So my position has not changed on this. I also know that you held a huddle the first Saturday after the October 25th, 2022 meeting, where the board approved the resolution, to which you reportedly stated to those who were on the meeting that it was a novel idea that was proposed to you and it intrigued you. So that leads the public to believe that, again, mistrust. Who set you up to do this?
May I?
Okay.
Okay,
Yes,
so anyone
Please,
who's ever had more than a 5-minute conversation with me knows I'm quite a nerd. Quite the nerd. So certainly when it comes to legal components, legal constructs, reading all these subcomponents in the Constitution, listening to all of the insight provided by experts across the board, including those that actually drafted this Constitution, who are still alive, who were a part of creating Home Rule and these subsections, yeah, I find that intriguing. Absolutely. I also see it as a great civics opportunity, which I've utilized it for. So finding something intriguing, I don't think is inconsistent with my character at all.
Okay. Again, I just want to thank all the commissioners, because a lot of the things that have been shared here today perhaps have been things that we've been holding and that have added to the challenges that we've had by not having open discussion about some of the things we're talking about here today. Commissioners, right now we have a, yes, did I hear somebody waiting?
I called a question.
That's what I'm getting ready to
A
do,
while ago.
yes. Right now we have a motion and a second. I'm going to go ahead and call the question. The motion carries 3-2 with Commissioners Sheffield and Richardson in opposition to recommendation 1. We are now going to recommendation number 2. Commissioner Richardson has a conflict of interest and will not be on the dais for our consideration of recommendation number 2. Again, just to,
I'm sorry, for a point of clarification, there's been a lot of recommendations to the wording, the way it is written, and I don't know, and Pam, I don't know if you have clarification, because I heard a lot of suggestions, but I had not heard where it was read into the record, what those recommendations are.
I'm getting ready to read what we just voted on again.
After the second one?
Recommendation number 1.
Okay.
Not number 2. Are you referring to number 2?
No, I'm referring to number 1.
Okay.
There was interest
Yes.
from some of the commissioners
That's
to
a very
revise.
good point. That's a very good point. So I think at this point do we need to reconsider the motion or revise the motion? Bill, to add the 2 additional conditions. One by Commissioner Gambrill, which was to refer to the Act 562, which was signed by Governor Kemp on March 6th, 2022. March 2nd, excuse me. 2022. And then Commissioner Burrow, I don't know if I have your language as you stated it. I have for this recommendation to be effective upon passage of this recommendation.
For the map to go in place?
For this recommendation to become effective, yes, which would put the map under Act 562, signed by Governor Kemp, March 2nd, 2022, to be effective as of the approval of that motion. There might be a better way to state that for our clerks, but it's to be effective upon our motion to approve this recommendation. Is that okay?
Yeah, effective. And the county manager said she would get with staff to start the process to implement it in the system, in GIS.
Okay.
I mean, we don't have a date because it's going to take them a while to figure that out, I think.
Okay. Well, it could be effective today, even though it may not be
Right,
posted
right.
until another time. So that was clarified. Do we need to take any additional action as we clarified that motion, Bill, or for our clerks? We're good? Thank you. Appreciate that. We will now move on to discussion of recommendation number 2, and Commissioner Richardson will recuse herself from this matter, which means as we discuss this, she will not be here on the dais. Bill, if you can help.
Yeah,
us with
Chairwoman,
that, please.
the second part of agenda item number 46 for background information says Cobb's enabling legislation states that, quote, a person elected or appointed as a member of the board from a commission district must continue to reside in that district during that person's term of office, or that office shall become vacant. Additionally, OCGA 4551A5 provides that an office in this state is vacated, quote, by the incumbent ceasing to be a resident of the state or of the county, circuit, or the district for which he or she has been elected. Following this board's now adoption of MAP 8562, of Act 562, the sitting district commissioner should no longer reside in the district. The request is that the Board of Commissioners approve a notice to the sitting district commissioner 2 that the office is deemed vacated, authorize the chairwoman to execute the notice pursuant to 4551, and for any other necessary documents for said purpose.
Thank you. I move that we approve that agenda item as it has been presented for purposes of discussion.
Second, for purposes of discussion.
Thank you. Okay. I see your mic on first. Would you like to
Well,
begin
no,
our
I'm just
conversation?
getting
or are you
ready.
okay?
I don't know where you're
Or
going to
Gabriel,
start.
are you okay leading us?
Sure, I will lead off on the discussion. I would like to have added, so where it says District 2 Commissioner that the office is deemed vacant, I would like to add per section 2-23B of Cobb County Code. So that is the only thing I have to add to that. And I will, do you want me to go and to clarify for the audience, the reason why I'm proposing that. When I started my initial legal challenge, it was truly by the actions of the board. There was never an intent to remove Commissioner Richardson, because as was stated earlier in the discussion on the first agenda item, I do believe we could have taken actions to preserve her position on the board. However, I have stood for the past 19 months with my statement stating that I am going to uphold the Constitution and the laws of Cobb County, Georgia. Our code requires Commissioner Richardson to be removed. It was never the act of the state legislature that removed her from office. It is our code. And that is where it is really unfortunate, because again, as lawmakers, we could have made that change, but we chose not to. So unfortunately, I am going to have to make a vote today that goes against the very intentions that I started out 19 months ago with.
Okay, thank you, Commissioner Gambrill. Commissioner Burrow, then Sheffield.
Can you repeat that statute again?
Sure, it's section 2-23B. Just for clarification, it's the election and term of members. It's specifically the last statement, or the last sentence, I'm sorry, that says a person elected or appointed as a member of the board from a commission district must continue to reside in that district during that person's term of office, or that office shall become vacant. But I don't know if the clerk wants to get that detailed, so that's why I just said section 223B.
That detail is actually in the agenda item. If you turn over the sheet that we have here, it's in the third paragraph of the background in the first sentence.
2-23B, okay. This is a tough one because I've tried to change our local enabling legislation that would allow Commissioner Richardson to stay in her seat. As soon as I realized that it was our local enabling legislation that was keeping her from serving because she didn't live in the district. And we have said all along that it wasn't fair she was drawn out. But again, we don't have those powers. So I do struggle with this because my statement says I will uphold the Constitution and the laws of the state. But I think as far as a vote tonight, I don't support this, giving notice and kicking her out of office. I think she should finish her term. So I don't support this part of the agenda.
Thanks,
Commissioner
Bill.
Schiffman.
There has been several references this evening regarding changing the enabling legislation. Can you just kind of give us a few bullet points for understanding the process in that? And it's also been presented as if that was a path forward, but the majority board decided to go in a different direction. If you can just kind of clear that up a little bit and
Sure.
walk us through that process.
The path to changing the enabling legislation would be under your home rule powers. It would be the same steps that were used to be able to change the map, except for the fact that it was very clear that one of the exemptions under the home rule powers is any action affecting any elective county office. And so clearly, or I would contend that clearly changing the requirement that a district commissioner lives within the district would be a violation of that.
Because I also thought, I heard a reference to an effort being made to change it. And I don't recall us talking as a board with respect to changing that to allow Richardson in her seat. In exec or otherwise. I just don't recall that conversation being had with this board.
It was brought up in March 2022, and also in April when we met regarding that possibility. And the Constitution regarding the powers if you can't change an elective office was referenced, and we did not believe that was a proper path forward.
All right, thank you.
Okay, so I'll Borough first, and I'll come to you, Gambrel. Thank you.
Okay, you referenced that this was brought up in exec, but that was for that, the part that says you have to live in your district. We all agree you have to live in your district that you represent, but it wasn't until Kelly's lawsuit, actually, that I was even aware that it was our local enabling legislation that went further than the state law by saying that you're removed immediately if you don't live in your district on January 1 of the year that you're in office. So it wasn't until Kelly's lawsuit to challenge the home rule that the county put in place that I was even aware that that was in our local enabling legislation. But when I asked about how we could do amend our local enabling legislation to mirror the state's to allow her to stay for the end of her term, which would be December 31st of this year. And then in January, January 1 of '25, she doesn't live in the district. Her term is ended, and if she's not running for reelection, she would be done. So.
Yeah, I don't think that decision.
And I was told that we would have to follow the same process we did with home rule to keep her in office, but it didn't have to be approved by the state because it was our local, and we could amend that.
No, you're enabling legislation, just like what you've done in home rule. This is the same. This is enabling legislation. It's not part of the Cobb County Code. This is your enabling legislation. So the only way that would have been done was through home rule. And just to point out, Act 562 also includes the qualifying. You have to be qualified in order for you to be able to resign to be a commissioner. This goes to qualification. Qualification is you have to live in the district.
But the state map was allowing her to stay in her district. In the committee, they agreed that she could stay till the end of the year.
Because the state cannot shorten a person's term of office. They could not shorten a person's term of office. They did not. She was no longer qualified because she no longer lived in her district. The state's not allowed to shorten any elected official's term of office. But when you become not qualified, then you're not able to no longer hold on to the position.
Well, that's not how it was explained to me. That's why I've been asking for outside legal counsel all this time, because there's conflicting decisions here, but conflicting information. And as you've all said all along, these are uncharted waters. It's never been done before. And we need someone that knows the proper steps.
Commissioner Gamble.
Sure, I just want to put it on the record that we're saying we cannot change our enabling legislation. However, in 2004, which is Act 836, and I believe it was signed by the governor like on May 31st, if I'm remembering my dates right at this hour. The board petitioned the legislature to change our chair's position from part-time to full-time. We changed the composition of office, term of office. We did that, or not we, but the board at that time was legislatively able to achieve that.
It's correct.
If a board,
local law would allow you to do that.
Right.
The legislature had to act, yes.
Sorry. So my point is, if the law enabled the board back in 2004 to change the term of a chairperson from part-time to full-time, that same law would have been applicable to us to change the residency requirements.
Yeah, if you could have convinced the legislature to do that, sure. The board could not pass any law. No law was passed to allow it, but you're able to always go to the legislature and ask that your enabling legislation be altered or changed.
Right.
That happens regularly.
Right, and it was countered back to me, well, it's a Republican-controlled legislature. They won't allow us to do that. To which my counter was, wait a minute, we're just adopting state law. Why would the legislators not allow us to revert to state law? At the minimum, we have to be in compliance with state law. Home rule authority allows us to be more restrictive. So essentially, again, we chose not to go back to the state and say, we want to be in compliance with state law. We know we've made our requirements more restrictive. We didn't do that.
I think what I'm hearing, Commissioner Gambrell, is that we do have the opportunity to appeal to our local delegation for that. I mean, right now, their session, though, is not until January, so at this point, that's not a course of action that we can take.
Yeah, the board annually always comes up with legislative agenda items. You have a breakfast with them and sometime in December and all of that. That always, there's other, besides the legal mechanism, there's always the legislative issues that you're always able to lobby legislators related to that.
I know when this was being considered during our last legislative session, I believe that now Senator Setzler was having a bill considered, and there was discussion with the committee with respect to keeping Commissioner Richardson in her seat until the end of her term, but that did not move forward. So I do remember having discussion down there during this legislative session. So there was an attempt, but again, it did not move through the committee. Commissioner Gamble, before I ask Bill a question, go ahead.
Well, again, if there was an attempt, we didn't follow the correct process to approach them. Because one of the things that we have to do before we can go to the legislators and get law changed is the board has to approve it. And I do not recall a vote by this board to seek changing our legislation through the legislative process.
I hear you, and again, that was not followed because it was already initiated by the senator. This wasn't something we were petitioning them to do because they were already doing it, but I did go down to express my support in the committee hearing. Again, it just did not move through the committee, but I did speak to other committee members and know that this was being considered as a condition of them supporting that measure. What I can share here is this. There's an observation in the language for OCGA 45-5-1 subsection B, that's at the bottom of the agenda item on page 631, that says the board shall provide notice of at least 10 days before proceeding to fill the vacancy. Does the wording "at least" give us opportunity to consider her fulfilling the end, when I say her, Commissioner Richardson fulfilling the end of her term, if we were to extend it beyond 10 days, since we need to get
Correct.
at least?
Under the local legislation, this board is responsible if there's less than 180 days left in the person's term to fill that vacancy. And so before tonight's request is that you declare that vacancy, but then that 10 days is then up to the person who receives that notice what they're going to do.
So the Commissioner Richardson, in responding, has at least 10 days, because I'm reading here, the board shall provide notice of at least 10 days.
Correct.
Okay.
So before you fill the vacancy, you have to provide notice of at least 10 days. So this starts
Okay.
that clock in order for you to be able to go through that process. Sometimes there's no notice that's required. There's no notice required if there's you're no longer qualified if you have a felony conviction. You're no longer qualified if you're dead. In those instances, you do not have to provide that notice.
In the time period where the vacancy is not filled, that doesn't necessarily mean that Commissioner Richardson is serving in that seat until the vacancy is filled.
Correct. Okay. That 10 days would be part of that process for her to have her opportunity to exercise her due process rights.
Okay. Yes, Commissioner Gambrell.
Since it seems like 10 days is going to now be questioned, with this agenda item, is it just implied that the board, or actually I think it says the chair, the chairwoman, to execute the notice, that she has to execute this within 10 days of this vote? Or is it open-ended as to when she has to execute this letter?
We have a letter for her to sign this evening, so.
Well, I understand there's a letter to be signed this evening, but again, it doesn't have a timeline on here to which it has to be done. Or is it implied that since we're taking the vote, the 10-day shot clock starts?
Well, it was start at notice, so if the motion is before the board, if you want to make an amendment to it.
Why would we amend it?
I don't know. You've made that inquiry to me regarding it.
Right, I inquired to you to verify for my own understanding that, again, OCGA 4551 says we have to give a 10-day notice. But in this agenda item, it doesn't say when we have to give her that notice. So my question to you is, if this agenda item is approved today, does that essentially force the chair to provide notice? Because if not, we could sit here and say, oh, well, we did the agenda item, but then, oh, the letter gets lost, we don't mail it, and then we send it out on December 21st, and it's a moot point at that time.
I can only answer that as we have a letter that's prepared, if this motion passes, and for the chair to sign. Maybe she would answer the question if it passes. So.
I have never, yes, if I've delayed signing any contract, it has been because I've had questions with respect to it. I've never just told a contract because I just disagree with it. I've asked questions and then I've moved forward, even on things I did not want to sign. So something with this much color, I would not be inclined to delay.
I have a question. I have a question for Bill. You mentioned a short while ago that the notice would be applicable if we're notifying her of a replacement or vacancy. But if she's going to complete her term, then why would we need to send the 10-day letter? Are we legally required to send a 10-day letter?
Well, the motion that's before you is saying that there is a vacancy because she no longer lives in her district. So I don't understand what about the component about completing her term.
Okay. Well, you mentioned a short while ago, and maybe I misunderstood, you mentioned that she is required to receive a 10-day notice if we find an appointment to complete her term, or did I misunderstand?
No, this body has a responsibility, since there's less than 180 days of her term left, to appoint a person to fill that vacancy. All right, the first component of that is this board needs to declare, if you're going to go follow that process, needs to declare that vacancy. That's what this process starts.
Right. Oh, okay, thanks.
Commissioner Plum.
But if we don't approve this at all, she finishes her term. Do we have to do the letter?
Well, if you don't approve it, there's no letter that would be issued.
Right.
Yeah, there's no letter that would be issued. And
If it's voted down, she'd finish it. Has till the end of the year to stay in her seat.
That would be
But she would represent the District 2 under the state map, even though she doesn't live in that district. But she would represent it, correct? I mean, we're still on the state map. We're still going back to the state map.
Are you asking Bill the question?
Uh-huh.
Okay.
correct.
Fine.
All right, is there any additional discussion? There's a motion and a second. All right, I'll call the question.
What is the motion?
To give
To
me
approve it?
authorization. Okay. The motion fails with Commissioners Sheffield and Burrell in opposition. Thank you. We are now at our second public comment. Before I do that, Commissioners, do you need a recess for 5? Are you good? All right, let's continue. We are now at our second public comment. Do you need a recess?
I need another bottle of water. Do y'all want water? Just bottle of water?
I'm good. Thank you.
The first public speaker is
I'm
Craig
sorry.
Harfoot.
Bill, let's take a quick couple-minute break, please. Welcome back to our Board of Commissioners meeting this August 27th, 2024. Our meeting is now called back to order, and we are at our second public comment.
And it's Mr. Harfoot.
Good evening. My name's Craig Harfoot, and decisions, choices, and natural consequences. Now, we heard a lot tonight, but who suffered? The taxpayers. All these lawfare suits, you got damages and, anyhow. Why didn't Ms. Richardson qualify and run she could have run against Joanne? I mean, if all these laws were in place in Cobb County, and if she moved out of her district and she knew all this, we used the state map to elect our Commissioner Burrell. And then you come up with a home rule map and cause all this lawfare. And when the Supreme Court, it was like, oh, you're out, you don't have standing, you don't have standing. But the Supreme Court said, look, they said enough stuff that I heard it, I watched it, and it said, it doesn't apply. The state decides whose map you get to use. But you proceeded with that. So you cost us a lot of money. And it's not only that. By her resurrecting the Lower Roswell Road project, she wasn't the district commissioner. Joanne Burrell was the district commissioner by the state map. So you need to go walk back all these things that you brought forward acting like your map was the right map, and all those actions for those county projects that it's like Joe Thompson buried Lower Roswell Road because of all the problems. And then I went and I tried to, with other people, to convince you what the problems were, and you just, we're going to do it this way, and you're pretty smooth. You really are, how you handle stuff, but it wasn't your district. And when it's not your district, it's not legal. And if you don't uphold your oath of, the Constitution of Georgia, that's grounds for removing 3 of you, because you're the 3 that voted for this action. And if not that, at the minimum, it'd be false swearing. That's the lowest threshold. You swear to do something and you don't do it. And the legal fees, you should go to your party and say, Cobb County shouldn't be paying the legal fees. Go to the Democratic Party, the big one, and say, pony up the fees, because this was a
Mr. Harfoot, your time's up. The next speaker is Sally Grubbs.
Good evening. My name's Sally Grubbs, and I don't think I could possibly be any more disgusted right now if I tried. First of all, I'd like to bring to your attention information about the Collaborative Firm, LLC, listing Cobb County as one of its projects on their website. The business is registered with the Georgia Secretary of State, and Michael Hightower is the registered agent. He's a former Fulton County Commissioner who confessed to receiving a total $25,000 in bribes from George Green, a Fulton County contractor. So I bring this up because someone requested that I did, who is not confident in coming forward themselves, but to talk about trust. We talk about trust, and yesterday there was a very big lack of trust in your meeting when we were scolded for even showing up. I know you seem a little bit confused, Chairwoman, but I specifically remember being in the room yesterday and one of the other commissioners excoriating us, with the Bloods and Crips comments, which was highly inappropriate, and then the highly, highly insulting inappropriate comment about being hung between 2 thieves and that kind of stuff. And so let me just say, there's clearly no honor among thieves. because 3 of you are sitting on that dais that have no business being there for putting this county, what you have put the county through over the last 2 years. There's violations of oaths of office. Just like Mr. Harfoot said, there is false swearing. There is injuries to voters. All I hear about, with one of the commissioners yesterday, I'm sure that Yashika Marshall in District 4 would never look down her nose at members of the community when they come to be part of the conversation. And when it was said tonight that this should not be hashed out on the dais, well, that means hashing it out in secret. And all of this is unacceptable. Treating people, constituents, the way that they were treated yesterday is unacceptable. Hiring someone with this collaborative group for $500,000 who is a convicted felon for taking bribes. It was said that I should talk to Ms. Gwen about it, this community development stuff. And I'm sitting here going, what difference does it make? Because you don't care. If you cared, 3 of you wouldn't be sitting there tonight. We hear about, decorum and integrity and character, and if there was any integrity or any character, you would get up and excuse yourself and the meeting would be over. But instead, we're admonished like children because we don't meet your definition of decorum. You raised your right hand, you swore to the Constitution, and you should honor.
Your time's up. The next public speaker is Kay Morgan.
Hello, everyone. My name is Kay Morgan, and I appreciate the opportunity to speak tonight. Madam Chairwoman, you said there has been harm to the county. You are correct. But the harm has been caused by a Board of Commissioners that chooses to subvert the laws of the state of Georgia and challenge the competency of our duly elected governor. This feud has now escalated to the lowest level of civil discourse I have ever witnessed in my 40 years in living in Cobb County. Comparing the constituents of Cobb to violent, drug-running, sex-trafficking thugs is unacceptable. You have all disrespected our county staff, causing a turnover rate that makes my head spin. You have tried to arrest fellow commissioners during a meeting. If this is what we have to look forward to in the next 4 years, I suggest it may be time for a change. Thank you.
Betty Hayden.
Good evening. I'm Betty Hayden, a Cobb County resident. From the East Cobb News Digest dated August 18, 2024, Election Board Attorney Daniel White wrote in Cobb's Superior Court on Friday that its opposition to continued legal action over the county and home rule map is rooted in the need for final resolution in this dispute. White said Election Board did not have a preferred outcome in 2 legal cases over the county's decision to use commission electoral maps that differed from those that the Georgia legislature approved in 2022. My comment in response to this is, it's not about a preferred outcome issue. It's about doing what is right and legal and legally binding according to the Georgia rule of law. The maps not only differed, but one map was legal, the other map was illegal. So why wouldn't the election board attorney align with Georgia law? And why wouldn't the Cobb commissioners align with our Georgia state rule of law, which you took an oath to uphold? For this court case to be dismissed as a lingering annoyance and trivial matter shows a disregard for our Georgia Constitution, and that should concern all the citizens of Cobb County. Judge Hill's response to the disenfranchising comment was as follows. Any disenfranchising happened when the elections under an unconstitutional map, when you change a district and keep people from voting in a proper district. Would you agree that is a voting rights violation? Judge Hill continues, I find it hard to believe that the county could not have foreseen or predicted the outcome that resulted in this case. Thank you.
Next speaker is Donald Barth.
Donald Barth. Good evening, ladies. You are a joke. You're really a joke. Do you remember that meeting yesterday when you said everybody should address the chair? You told Commissioner Gambrell she had to address the chair. You referred back to Miss Joanne. But then you turn right along and let her dress her down. You let her dress me down. Are you stupid or what? Are you stupid? You're not a good attorney. You're a great equivocator over there. He comes in here and he says, what do you want me to do, Lisa? And then you wonder why there's no trust. What is trust? You earn trust. You haven't earned anything, lady. You're taking the county money. You can sit there. You're probably medicated. You're sitting there taking on all I got to say. I don't care. You have been the worst thing for Cobb County. In fact, I don't know how we could get any worse than you. We just couldn't. If I stepped in some dog mess and I went over there and I said, oh, Billy, do you think I got some dog mess on my shoe? If that man right there said, yeah, I'd say, nope, doesn't look like dogs. You can't trust that man. Two ladies told you that yesterday. They told you that. You spend your time trying to cheat the people of Cobb County. I did this for the people of Cobb. No, hell you didn't. You don't do anything for people. You steal and lie. That's what you do. You got minions up here. You are a minion. Don't you tell me what to do. I don't work for you. You work for me.
No, I do not, sir. And you will lower the tone of your voice. I feel threatened. I feel threatened.
Oh, you are a drama queen. Oh,
I feel threatened.
You are a drama queen.
But I don't feel safe right now.
Oh,
Us is being very
officer,
aggressive.
lead
Very
me out.
aggressive.
Come on. Come on. Is my time still there? Save my time.
The next speaker is Mike Dunlinger. Mike Dunlinger.
Good evening. My name is Mike Dondelinger. I'm a citizen of West Cobb. I'm a retired county employee. I rise before you today to ask this board to curtail or stop the extravagant spending of the current sheriff as it pertains to things that have no value to incarcerated persons or to our citizens. For my brothers in gray, I remember sitting in the 97 housing dorms, sweating through my uniform with you because the air conditioning was not working, while we joked about using the AC in the sheriff's $170,000 Mercedes Sprinter van party bus that was parked in the intake yard. I remember the despair in the deputies' faces. I remember it. I remember trying to control unruly mental health inmates who wanted to harm themselves that were in normal concrete and steel cells because the jail padded safety cells were severely damaged and not usable, while $350,000 was spent on horses, trailers, and trucks. I watched as those stalls continued to not be fixed as we, the taxpayers, pay the monthly upkeep for the horses. I remember the helplessness. I remember. For my brothers in blue, I remember your nightly treks to the hospital for inmates who refused to answer medical questions when they had no apparent injuries. I remember. Lastly, I ask the board to curtail his spending. Please save some money for the next sheriff.
Beth Childress. Beth Childress. Gabriel Sanchez.
Hello, everyone. My name is Gabriel Sanchez. I am the candidate for Georgia State House District 42 in Smyrna. Okay. Sorry, my bad. That's my bad. I'll recuse that part of the statement. My bad.
Thank you.
My name is Gabriel Sanchez. I'm a resident of District 2. And I just want to thank the commissioners on the board for making a great decision. And I'm very happy that my commissioner, Jerica Richardson, will still be commissioner and representing me, because I think you've done an amazing job, and I'm very excited to see you fill out the rest of your term. So, and thank you for all the work that you do. I also want to thank the rest of the commissioners as well for such a lively discussion today. And, you know, I do want to thank specifically Commissioner Burrell and Sheffield as well for voting to keep Jerica in her seat as well. So I appreciate that as a constituent of District 2. I just wanted to set the record straight as well, because there's been a lot of discussion about this. And, you know, none of this would have happened if the Republicans in the state legislature did not circumvent the normal process that had been done for decades in Georgia for making maps and going out over the heads of the Cobb delegation to make their own map to draw Jerica Richardson out of her district. For the people who supposedly care about all this law and order stuff, they don't seem to care about the fact that the Republicans broke their own rules in the state legislature. And previously I worked as a redistricting expert for the organization that I worked for, and I was there when they were doing these crazy things, not just in Cobb, but in many places around the state, gerrymandering the hell out of Georgia because they want to keep power, because that's what they care about. And that's why we're here, because those Republican legislators are upset that they have lost power here in Cobb County, and so they're doing everything they can to create chaos and undermine this county, because they'd rather do that than actually serve it. And that's why we're here in this position. And so they are the ones to blame for this, and I don't know why the people who are out complaining on you, when they're the reason that this is happening in the first place, and they're not saying anything to them about it, like Senator Ed Setzer, who led that charge. So spare me with your considerations of law and order and what's right and what's constitutional when you don't even bother to put the same standards on your Republican allies. So we all know this is all partisan here. So I just want to set the record straight, because I know that both Commissioner Richardson and Chair Cupid were there at the state capitol advocating and trying to create a bipartisan deal to make sure that she would not have to vacate her seat, and the Republicans refused to do it in the end. So we did try to go through every single path we could to try to stop this constitutional crisis that they created, and they stopped us at every turn. That's what ended up happening, and that's why we're in the situation here today. So I just want to make this sure the record is straight and clear that this is why we're in this spot today, because those Republican legislators in the State House and State Senate are trying to sow chaos and undermine our county here.
Mr. Sanchez, your time's up. The next public speaker is Mindy Seeger.
Good evening. Mindy Seeger, resident of Cobb County District 2. I wanted to there's been a lot of lively conversation tonight about kind of where we are with this. And as someone who was a named party in the most recent iteration of lawsuits, and I actually filed for clarification for just this reason, because the ruling talked about future elections, talked about future qualification, but it did not spell out in letter what we were to be operating on as a county. And that was why I asked my attorney to file for that clarification, so that we could have a clear understanding if that was part of the ruling or if that needed to be part of a separate procedure, and what the actions were to that effect. I also want to go through a few things because as I have been deeply vested in this and have read literally a stack of legal proceedings that have occurred on this that is at home, that is this thick, to the point that earlier when we were reading Section 223B, I was reciting it verbatim because that's how many times I've read it and explained it to the community, to members of the state legislature, to anyone who would listen. So I know that piece very well. So I wanted to go through a few kind of myths, facts, questions. One is that 1154, which was the bill that was put forth by the legislature, avoiding the local delegation means immediate vacancy. There are a lot of opinions about this. That has never been litigated. It was brought up in the hearing that it might be a violation of OCGA 1311, which talks about shortening or lengthening a term of office, which the state legislature cannot do without a referendum. There have also been questions about 223B, which talks about a commissioner shall continue to reside in that district. And I have heard it opined to me that even that district is a question. Does that mean that district as a snapshot of time upon election? That numbered district, which we saw, I think it was Gwinnett, changed their district numbers? Or that district as it may evolve through a commissioner's term? That also has never been litigated because it's never come up before in Georgia history that we could find. The fact that there's a myth that the county drew its own map. That never occurred. Both maps in House Bill 1154, which was signed by the governor, 1256, which was never given the proper hearing channels, which was the delegation's preferred map, was not granted a hearing. Both of those went through the apportionment office, and that is evident because if you look at both of those maps, it tells you the username on each of them. One was put forth by Representative John Carson. One was put forth by Representative David Wilkerson and then pushed through the legislation through then Chair Eric Allen. There has been a myth. I think my time is up. There's more myths and facts.
Ms. Seeger, your time's up. I'm sorry. The next public speaker is Alexis Alexander.
Good evening. I am Alexis Alexander, and I am a Georgia resident. I am coming to speak to the board in regard to some concerns that I have regarding some of the things that are coming up for approval for this county. In the water, the transportation, the public safety, and the risk safety categories that you had up in the upper numbers before number 20, there are a lot of requests for additional vehicles and miscellaneous services. These companies are asking you to approve their request, but if they're not necessary or beneficial, then they're basically just running up the county's budget and affecting the mill rates for homeowners' taxes. Many times these departments' issues are with manpower, not necessarily with equipment. For number 19, number 45, which is the 911 emergency communications, and all of the 3 emergency communication requests, they pertain to informational technology. And at present, for the last 12 months or so, we've had some major hacks that have happened with Delta and with Fulton County. And with all of these new requests that keep coming up from district to district to district, almost like a trickling effect, it really makes you question whether or not there's something that's really going on that's a problem of concern. I know that personally, I know if I was on the board, then I would be very leery about doing anything in regard to information technology at present. approving contracts for the departments that they're coming from. I feel like there should be some money that is actually going back to those departments for emergency funding. Where is it on here? For emergency funding, if in the event there is some type of liabilities that end up occurring once the contracts are over, because the contracts only last for a certain period of time. But after that, what happens then? You have $1 million contracts that have actually been approved, but then again, when they're long gone, these were not the responsibilities of the county. They were actually the responsibilities of the contractors. So where's the money that was all taken out of that department? Also, I feel like a certain percentage should go back to liaison with the counties, because a lot of these contracts that you all are approving for all of these ridiculous amounts of money are actually taking away from some of the
Ms.
help that's
Alexander, I'm
already
sorry,
there.
your time's up. Chairwoman, that's the last of the public speakers.
Okay, thank you. I believe that takes us to the Commissioner's public address. We'll begin with Commissioner Gambrell once her slides come on the screen.
Pick your team and support senior meals. Cobb County employees will compete in a mixed doubles pickleball tournament from 1 to 5 p.m. on Friday, August 30th to raise funds for Meals on Wheels. You can come watch the action at Jim Miller Park at 2245 Callaway Road Southwest in Marietta, and your donation can help to ensure that Cobb seniors receive the meals they need. To donate, you can scan the QR code and put your favorite team in the donation line, and they will get credited for your amount. Thank you for your support. Cobb Animal Services is offering 2 free vouchers per household per year through its Snip the Bill Spay and Neuter voucher program. Cobb pet owners can pick up the vouchers from 10:30 to 4 p.m. on Tuesday through Sunday at 1060 Al Bishop Drive. The vouchers are valid only at West Georgia Spay Neuter Clinic in Douglasville or the Community Cat Clinic in Woodstock. I've had several people ask me how they could help contribute to this program. If you are interested in donating to the Spay and Neuter program, you can send your donation to the Cobb County Animal Services, and in your memo line, just notice that it is for the spay neuter, and we thank you for your support. Lastly, we wish you a safe and wonderful Labor Day weekend. All Cobb County government offices will be closed in honor of Labor Day on Monday, September 2nd.
Thank you. We'll now go to Commissioner Richardson.
So I'm just going to say ditto on the Labor Day because that's my opening. We'll be closed in recognition of Labor Day. We hope everyone will be able to spend a relaxing time with their loved ones and friends this holiday weekend. Stay safe and have fun. As far as out of the office, we do have our Lighting District's community chat coming up on Thursday. Do you live in a corridor where you can't even see your own feet at night? Do you want to learn how lighting districts are making a difference? Join the D2 office in Cobb County DOT for a Lighting District community chat to help bring awareness to all of the unlit corridors. This is according to the old map. This is a great opportunity to add your voice and highlight the areas needing greater visibility from dusk till dawn. You can register here and learn all about how to get those established and some of the other strategic opportunities around the district. From the community, how to meet get a discount for a clean out. Let me make sure this is the right thing. Yep, Cobb and Douglas Public Health, using an American Rescue Plan Act grant, will provide a one-time water bill credit up to $250 to primary Cobb homeowners who get their septic tanks pumped. Homeowners who participate in the program will receive a credit of up to $250 based on the actual cost of service after having their septic tank pumped by a state-approved provider. Eligible services must be completed by September 30th, 2026, or until grant funds are exhausted, whichever comes first. This initiative aims to encourage regular septic tank maintenance, preventing system failures, protecting water quality, and ensuring a cleaner, healthier environment for all. Homeowners interested in the program can enroll by clicking on a link. But for more information, just email cdph.environmentalhealth@dph.ga.gov or call 770-435-7815. That concludes all of the comments, minus, of course, all of the upcoming meetings and huddles for the office.
Thank you, Commissioner. We'll now go to Commissioner Burrow.
Bring the kids and join the fun for the 2024 Cobb 911 Kids Expo, September 7th from 10 a.m. to 12 p.m. It's at Cobb 911 Headquarters, 140 North Marietta Parkway, Marietta. Learn safety tips such as when to dial 911, see how dispatchers answer calls, and you may even get to talk to first responders on the radio. You may also spot Turbo, the 911 tortoise. September 11th is Senior Citizen Day. Celebrate National Senior Citizens Day from 11 to 1:30 at Piedmont Church, Wednesday, September 11th. Festivities include lunch, music, and entertainment, and awards will be given. The cost is $10 per person. Seating is limited, so register by August 31st. You can email info@seniorforcobb.org or call 404-500-8601. And happy Labor Day. Take some time to rest and relax on Monday. And I'd also like to say thank you to all who showed up tonight for support or opposition to a long and lengthy meeting, but the accomplishment was done. Thank you.
Thank you, Commissioner. Commissioner Sheffield.
Thank you. Before I move through my slides, I just want to, to just share a couple of things. And, I'm just a little perplexed when it comes to exercising our First Amendment right. When some express their views, they're expressing their First Amendment right. But it seems that when others, particularly if those comments don't align, then that person is not expressing their First Amendment right. Instead, they're being abusive and they're being inappropriate. And I'm just not sure why that is the case for one and not for the other. Because for the display here tonight, particularly of the person who I felt threatened by, that is inappropriate. Me sharing my thoughts and my feelings, and I dare say exercising my First Amendment right, is just that. It is my right just as it is anyone else's. But that behavior is inappropriate. And for anybody who thinks that it is not, then you have some soul searching to do. What I also think is inappropriate is when we have leaders in Cobb County who, on the one hand, and this is not directed to any of my board members, on the one hand, want to uphold the Constitution, but travel to DC to participate in the January 6th event to prevent the very thing that they hold true to themselves. And that's an act of the Constitution. Search yourself. Why is it appropriate in one regard and not the other? For months, we have dealt with vitriol to the point where case law has been presented to the board to support to support a position of someone being disrespectful and full of vitriol. And Commissioner Richardson, I'm sorry, I have to share this. You have been very graceful throughout this entire period. She have received very disgusting emails. And please excuse my language, but I am going to repeat just one of the emails that she received. And I quote, "Since you are pregnant, I will come to your office and help you pack your shit. Can you please explain to me where that is appropriateness? Can you please explain to me where the appropriateness is in that?" And this is coming from people in the audience who receive thunderous applause because they're thought to be charming, but they're not. Candidly, they're cowards, is what they are. So as we move forward, and Brad, you can keep me honest on my 3 minutes, that's fine, I'll
You're
forego
over
my
45
presentation.
seconds.
The chair mentioned earlier there was something done to us, but we did not come together to get past it. Hopefully at this point, we can, and that's all I have.
Thank you. That's how I was going to end my remarks, so that was a good lead off, is that this was done to us in Cobb County. And it has been hurtful to our county. But that doesn't mean we don't heal and move forward. We've got to. We have to. It's not about home rule. It's about making Cobb County home to everyone who lives and does business here and visits here, that this is a county to be in, that we're a great county. You know, just with every family, I think there are challenges. But just because there are challenges doesn't mean we're not family. We've got to move forward. And we have a path, part of a path to do so, with supporting our first recommendation. I look forward to us getting past the second and figuring out how we can continue to make Cobb County a place where everybody wants to be. And I always tend to look at the silver lining, even in the face of vitriol, is that there's better on the other side. And there's better on the other side of what we experienced tonight. And let's get to that better. We can do it. It's up to each one of us, irrespective of what somebody gives to us. We don't have to return that back ever. We can be better than that, and we are. We're Cobb County. With that, let's have a good evening. Our meeting is now adjourned.